thing is, this is a contempt matter in which the incumbent has left the office, has resigned. So there was a direction to serve upon the incumbent. Now, my lord, unless the cause title is amended, I cannot serve upon the fresh incumbent in the office. May this appear?
Friday,
Ma-
you mentioned on Friday.
My lord, by a
This is time, but this is supposed to come up on 20th of August. I
So
will not.
This
have
is not
time to-
correction of the order.
No, this is
You were
not.
supposed to provide the name of the new incumbent to incorporate the name of the new incumbent.
It's just a
Huh.
leave.
my lord,
Come on, Friday.
my lord, by yesterday, when notice has been served, within 3 days, new service will be terminated. Service has already been terminated, and new application for
On Friday.
my lord, kindly by 13th.
My lord, kindly
You
for
again-
correction. On
Lordship,
31st July, my lord, small correction.
What is the correction?
31st July. 31st July, my lord, the order dated.
What is the correction?
Petitioner on the last paragraph, my lord, first page on
The same.
first page, my lord. The last paragraph, 9th December 2021, my lord, mentioned that is 2025.
Okay,
Last-
we mentioned 25. Yes.
My lord, within a period of 3 days, my lord, the applications will be
Item-
over, and my
Rahul?
Yes, Lordship. Item number 1 is for non-prosecution, Lordship. The written instruction is over here. Yes.
What is this revisional application for? This is for quashing. Who is Mr. Ramaswamy Mukherjee?
I was appointed as the amicus curiae, because since nobody appeared initially. Now got the information, now the client has contacted the erstwhile advocate.
What is the stage of trial?
Petition that? Stage of the trial. 2011%.
Petition is not.
Grant আছে তো grant?
Petition টা নেই?
Petition.
101017 grant. We extend them. Extend the interim order. What is the stage of trial?
I cannot apprise you lordship at this stage because the petition has not been served. I was only appointed as the amicus curiae. Thereafter, my lord, No, what is the stage of the trial?
Trial framing of charges.
Framing of charges, मतलब 2011 में उसे ना petition का শুনুন সব করুন আমার কাছে কি appointment ছিল তারপরে আর কোনো কিছু আমাকে
The report was called for from the state.
yes
Notice dispensed with. You give a notice to the learned advocate for the state. It will appear on Calcutta. Next.
मतलब erstwhile advocate मतलब then he has to मतलब carve afresh upon this state.
This matter is appearing under the heading to be mentioned. Learned advocate for the petitioner submits a petitioner. With amicus.
Later direction be passed to obtain the copy from the department because you do not have the copy of the revisional application.
Which copy?
A copy of this revisional application.
You do not have.
My lord, may I assist you, lordship? My lord, in this matter, the erstwhile advocate who was filed this application, revisional application, she died. Thereafter, very long time, nobody was appeared on behalf of the petitioner. The Honorable Court was pleased to issue rule against the petitioner. Appeared, Mr. Mukherjee was appointed as amicus curiae, but he has no copy of the application. Now the client's daughter contact with me to take up this matter and withdraw this the same. My lord, we have also not been in position to supply any copy. My lord, if your lordship direct your court officer to provide a copy or otherwise a certified copy, may I
To
sir?
get the certified copy
And then
placing it after 10 days. Get the certified copy of it.
and my lord, she told that the trial is on the stage of framing of charges. 7th December,
What you do is
August
give a
was fixed
notice
for.
to the state.
My
Huh?
lord.
On Wednesday, these matters are being taken up. Give a notice to
But
the
that
state.
person
Call
is
for a report from the
bedridden and,
state.
he is about for 85 years old and suffering from various ailments. So my lord, kindly give a shorter date so that we can come back.
Next week. This matter is appearing under the thing to be mentioned. Mr. So and so, learned advocate. You have filed your wakalatnama?
My lord, no, as Mr. Mukherjee is appearing. On,
Who will conduct?
amicus
I was
curiae.
appointed as amicus.
Amicus curiae. That's
Oh,
why
he-
I contact Mr. Mukherjee.
Okay.
He gives the consent.
Mr. Ramasis Mukherjee, amicus curiae, appointed by this court to represent the petitioner, submits that the petitioner does not intend to proceed with the present case. None appears on behalf of the state, learned advocate for the petitioner. Petitioner directly to serve a notice upon the learned advocate for the state, intimating the next date of hearing. Next Wednesday কত তারিখ হচ্ছে? ওটা টু বি মেনশনড দুটোর সময়ের আগে। দুটোর সময়?
তুমি আমার ঘরে বন্দুক পেড়ে
19 আমরা দুটোর সময় নিয়ে রে। Revisional application is taken up at 3:30. So on Wednesday, not this Wednesday, the next Wednesday it will appear. 19. In the meantime, you give a notice to the learned advocate for the state.
Along with the copy of the application, along with this order. Otherwise, they will not accept. The PP office will not accept the. Kindly indicate that much in the order, much.
Give intimating the next day along with a copy of this order.
Much of it.
এটা না শুনুন টু বি মেনশনডই রাখবেন সেদিনে 3:30।
Two, madam, for
Who?
the container number 2, madam.
Till
we
date,
added
nothing
container.
has been complied with manner.
But I have-
Several times took
Mr.
time to comply with the said order.
Parsu learned advocate for alleged controversy seek some accommodation to take steps. What steps have been taken?
This is the report matter. But the entire matter has been informed by the NPO by. Since that
SDO.
the report is filed manner, kindly comes to manner page 5, 6, Five.
Have to take steps for disbursement of amount of rupees together. 20 with 15.
That is the communication.
You are for?
But I am for the container number 2, the edit container with the erstwhile video, madam.
Okay.
My lord, my lord, kindly come to my lord, page 9, my lord. The new DM has, my lord, joined. Kindly allow us.
এই আমাদের কপি দিয়ে দিই।
Time, my lord.
না আমি তো একটা কমপ্লেন্স রিপোর্ট এফিডেভিট করে আগেই ফাইল করে দিই। এটার কপি ওদেরকে দিই।
Page 7, my lord, that is the entire fact has been narrated by the
Seven.
video, the present incumbent, my lord. And on the basis of the communication, my lord, and the basis of the entire narration of fact, my lord, the DM has
So where is the allotment of fund?
my lord,
On 20th May 2026, DM writes to the SDO that there is a matter pending before the Honorable
inquiry is
Court.
completed, my lord.
In 26th May 2026, he says that yes, these work orders were issued and orders were complied with, completed, necessary allotment, arrange funds for necessary.
My lord, the new DM has joined, my lord. My lord, kindly allow us some time, my lord. My lord, order,
Mr. Devasis Basu, learned
my lord, order will be complied, my lord.
advocate representing alleged containment number 1
One.
seeks further accommodation, submits that steps have been taken by the district magistrate Uttar Dinajpur, pursuant to which inquiry has been held by the block development officer and report has been submitted. He seeks further accommodation to comply the order of this court. 10 दिन পরে লিখব। After 10 days, I am fixing a date.
10 days, my lord.
আচ্ছা, এটা affidavit of
My lord,
compliance.
kindly allow us, my lord, a month's time, my lord.
1 month.
My lord.
Make it after 15 days. 2 weeks.
My lord, kindly, my lord, make it.
But I have
One
already
second.
filed my affidavit of
The lord's
compliance.
order will be, my lord, duly complied, my lord.
3 weeks পরে রাখুন। Please this matter after 3 weeks. আর এটা হচ্ছে affidavit filed by Alice container number 1. Copy দিয়ে দেবেন। It's taken on record.
Habibur Rahman.
আমারটাও দিয়ে দিয়েছি।
Application.
না লাগবে?
After 3
তোমার
weeks.
আমার তো অ্যাটলিস্ট কিছু ডকুমেন্ট কম। গেটফুল চলে
3 weeks. To পাঁচ নম্বরটা
Millard, before Millard, the is not the right time, I know, Millard, to mention, Millard, may I have my lord's Millard extreme indulgence?
No.
Look, I'm paying for 4,000. Paying for 4,000.
I am content our my lord. I have no instruction. I have no submit the affidavit. I have no instruction to my class.
What instruction?
Favorite possible, my lord.
Which one?
Item 5.
After five.
The applicant in CPAN
Five and another. Others.
950 taken on record. You are for?
I am for the content. I have no instruction, my lord.
You are appearing for whom?
Submit.
The CPA number will allow me CPA.
You are appearing for whom?
I'm appearing on CPA number, my lord, 950. 950.
You are appearing for? Petitioner in which application? There are two applications.
Lordship, I have further instruction to go in for passport.
Application for my lord. Halim Khan.
I am for the,
Number 950.
this case, my lord, I am for the contemner, Halim Khan. Contemner I am.
No, Halim Khan is a private respondent.
And no. Liliman, Liliman. Lilima Pradhan, from Panchayat.
Okay, pass over হবে। একটাতে রুল ইস্যু হয়েছে, একটাতে রুল ইস্যু হয়নি।
Traffic congestion আছে না?
ও তাহলে চেঞ্জ করতে হবে, লিলিমা জানা। আসুক, ঠিক আছে। Fast over. Wait for him. After 10 minutes. 10 minutes of pass over. Ask him to come.
I am.
Important. As per your lordship direction, my lord, just a quick. I have served the notice to the present alleged contemner. They have received it.
Who is the alleged contemner?
Now the Pradhan. Pradhan.
Is Priya Das.
Along with the affidavit service, my lord, your signature. I have also annexed, enclosed the server copy of the order 14 July 2026. My your lordship kindly comes the contempt application page 47. On 29th October 2025, an order was passed directing the melody from the Pradhan to cause inquiry in presence of all the parties and to hear and pass a reason order. The complaint was that in my property, that without taking any permission from the Panchayat authority, school authority encroaching my land, construction is there. Now, your lordship passed this order, directing the Panchayat authority to take step accordingly. No step has been taken. A reminder was order communication was there. Thereafter reminder was also there. Thereafter they have done nothing. And as per your lordship direction,
This is that 3 cutters of land.
3 cutters of.
They say that there was give deed.
Yes. Now the school authority taking the advantage of there is no boundary, they have constructed without any permission, nothing.
Ashun, affidavit of service filed on behalf of the petitioner is taken on record. It is found from the purported affidavit that it is found that the service has been effected upon the alleged contemner. Para, despite service, none appears on behalf of the alleged contemner. The present complaint application is preferred in relation to order dated 29th October preferred in relation to non-compliance of order dated 29th October 2025 passed in WPA 11383 of 2024. Accordingly, issue rule 8 September 2 p.m.
8 September.
You put in your requisites.
Yes.
Applicant is directed to put in necessary requisites.
8 September 2 p.m. And 8
times. This is the contempt of the first time. The lordships kindly see the lordships order, page 22, the operating portion, the bottom portion, page 22. 21, sorry, page 21, the bottom portion, in view of the above, considering the submission, lordships passed an order, the specific direction stated by my lord, The entire exercise shall be completed within a period of 2 months from the date of communication of the order.
Notice issue.
This communication has been done. Nothing has been taken steps, neither inspection, neither. On the paragraph 9, I have stated there are no steps have been taken by.
Notice 4 weeks.
Nine, my lord, I am for the petitioner. I am for the alleged content. Oh. My lord, the previous source. My lord, page number 15, my lord, the order.
Mehboob Asif Jaman. Yes, Mr. Das.
My lord, what happened, my lord? It's an application for medical ground. My lord, immediately after receiving the order letter of the communication, my lord, though it is not been annexed when it is communicated, my lord, we immediately send the matter to the CMOH for medical opinion. My lord, CMOH till date has not sent us any report. Be that as it may, my lord, we are sending the reminder again, time and again to the CMOH, and my lord, we are conducted an hearing just before 2 days ago, where my lord, the petitioner is present in the office. Well,
No, medical has been done.
no, till date not has been done.
So how
But,
could we hear the matter?
My lord, here is a resolution where the petitioner has herself signed that my lord, he is agree and willing to wait for the medical report.
My lord, let him show, my lord, the date. Your lordship kindly see. My lord, kindly 2nd July. My lord, today we are, my lord, 11th August. My lord, DI simply, my lord, tight over the matter, my lord.
2nd July.
We have communicated it, my lord, February, 11th February 2026 by hand. The order was communicated. Your lordship's blessings was communicated, my lord, on 11th February.
We are not denying. We are not sending it
My lord,
away.
what they are, my lord, they are not the DI, my lord. Now the chairman in charge is not applying his mind. My lord, two aspects of this matter. My lord, one is, my lord, the medical. The another is, since I have crossed, my lord, I am serving more than 10 years. My lord, I am, my lord, posted, my lord, far away from my residence. My lord, I am staying over there, my lord, alone. My lord, there are, my lord, certain, my lord, medical ground as well as my distance ground. My children, my lord, my husband, my lord, my father-in-law. From them, my lord, I am far away. My lord, the two grounds. My lord, one is, my lord, this medical. Another is also, my lord, distance. I could have understood, my lord, the medical was not done. But the other ground, as per the act, as per the rules, my lord, I can be, my lord, given. But that was not also, my lord. That was not considered. No reasoned order was not passed. Now, my lord, after filing of this content, my lord, they asked, my lord, when my husband, my lord, went there to, my lord, give this order, to communicate this order, my lord, they said, you wait. I'll give you the order for conducting the medical.
Because when can this medical be conducted? You file an affidavit of compliance by conducting the medical within a period of 2 weeks and file the affidavit of compliance.
I take the suggestion from my learned friend. But if he ready and willing to proceed with application with a distance ground, I immediately ask my client to immediately comply and take a decision. But if he consisted upon the medical ground, well, we have to wait from the report of the CMH. CMH is sitting tight over the matter.
Your client has appeared before the CMOH.
No, my lord, no.
You take the matter up with the CMOH, or else
My learned friend has understood.
And
My lord,
the CMOH has a alleged contempt.
my lord, if the DI considered that yes, I can be transferred on the distance ground, then the medical is not required at all under the law.
But then he has to decide that, because I have given him liberty to seek
Yes,
medical
yes,
examination.
my lord.
If my learned friend is undertaking to proceed his application in a general ground or distance ground, I here and now that direct the DI to immediately consider his case under the general ground. But if he insists on the medical ground, we have to take an opinion. My lord can see in my lord, we have sent it in a June to CMOH.
file these documents by way of an affidavit, and in the meantime, you ask the CMOH, issue a direction for CMOH to conduct the medical
My lord,
examination.
again and again, my lord, we are giving the reminders to the CMOH.
Affidavit of service filed on behalf of the petitioner is taken on record. Mr. Ratul Biswas, learned advocate for the applicant petitioner, submits that since passing of the order in January on 22nd January 2026, no further steps have been taken to consider the representation of the petitioner. The medical examination is yet to be conducted by the CMOH. Mr. Gaurav Das, learned advocate representing the alleged contender, submits that the chairman DPSC South 24 Parganas,
Chairman in charge, my lord.
chairman in charge DPSC South 24 Parganas, alleged contender has already taken steps for examination of the petitioner by the concerned CMOH of the district. However, till date, no
My lord, one
date
is
has been
June,
fixed.
one is June, and another is August. My
In
lord.
the
Another is August.
in the month of June 2026 as well as on 7th August 2026. However, till date, no date has been fixed for examination of the petitioner by the CMOH for medical examination of the petitioner. For such reason, the representation could not be considered within the time frame. He seeks some accommodation to comply the order of the court. It is found that for want of medical examination, the further course of action could not be taken. The chairman in charge, the alleged contender is directed to take up the matter with the CMOH for expeditious medical examination of the petitioner.
My lord, may I indicate one thing? Along with
Is
this
this-
order, copy of this order.
Alleged contender is directed to serve a copy of this order to the CMOH, which is MR Bangur.
MR Bangur.
MR Bangur Hospital for necessary compliance. Release this matter after 2 weeks. Affidavit of compliance be filed by the alleged contender on the returnable date.
এগুলো দিয়ে দিন আমি কমিউনিকেট করো স্যার ওই
Copy of the notice. You give a copy of that, or
Well,
by way of an affidavit, you can file on the
Yes,
returnable date. এটা return করে দিন আপনি। এই communications গুলো হয়েছে return করে দিন।
আমি একটা জেরক্স করে দিয়ে দিচ্ছি, এটা থাক।
Item 10, my lord. I am for the petitioner, my lord. First time coin contempt application, my lord. Order dated, my lord, 25th February 2026, my lord. Page 26. Page 29, my lord, para 13. Page 37, my lord.
Was ever mentioned in God as chemistry.
Communicate my to dear.
Page number
37, my lord.
from District Inspector of Schools to the Head of Inspections. Papers. The school has submitted.
Yes, my lord.
Papers have been submitted by the school.
Yes, my lord.
Question level in terms of order date and department. Why this was revoked? What is the reason for revocation of that memo?
No reason, my
Page 38.
lord. Page 38, my lord.
Page 38. Why it has been revoked?
Without any reason, my lord. For that reason, I filed contempt.
Oh. Notice is given. Issue notice 4 weeks for us.
Lordship, grateful for the time. Lordship, I'm for the petitioner here. In the last order dated 10/7/2026, your Lordship directed to file an affidavit of compliance.
Yes.
Whereas the alleged contender haven't filed anything, and thereafter they have taken time twice. And till date, no steps has been taken.
But the client could not contact to me, so I am not filed the affidavit.
Yes.
Client could not contact to me.
What phone?
I have no knowledge.
Respondent.
What is your
application number 950?
950? What is your
this matter? In this matter, my lord, as per order of this honorable court, my lord, respondent number 3, my lord, compulsory Pradhan, issue a notice, my lord, page 68, my lord.
Notice has not been issued.
Issued, my lord. In a state way for demolition without any inquiry following the guidelines of this order, my lord. State way issue a notice, my lord.
Where is the notice of demolition?
Page 68, my lord. Respondent application, my lord.
Yes. This notice has been issued directly for demolition without causing any inquiry. An inquiry was held.
Lordship, we have received one notice regarding that there will be an inspection done.
No, my lord.
I think an ex parte.
Where is the resolution?
If
If there is no resolution, then how can you are carrying 950? 950, the copy is with you. So there is a observation that the construction made by the private respondent is illegal. Then there has to be an inquiry and a resolution. And again in the second paragraph it says that to remove it or we will demolish it. But the panchayat has no authority under 23 to demolish. It will refer the matter to the SDO who will cause an inquiry and hearing and thereafter pass order for demolition. If the contempt application has been filed and a rule has been issued, that does not mean that you will not follow the instruction or the direction that was given in the earlier order. You give a notice, cause inquiry, hear the parties, and thereafter, if you conclude that yes, there is illegality, you refer the matter to the SDO for taking necessary action. That is what is under 23. Issuance of rule does not mean that you flout your own the order passed by this court. You come up with a report, give a notice to both the sides, cause an inquiry, and thereafter file your affidavit of compliance. Till such period, the notice dated 3rd July 2026 should not be given effect to. Or no coercive steps be taken in terms of that notice. You come up with that. What is your resolution in place before this court? Let us examine that.
Lordship, she's seeking 10 days time. She's seeking for 10 days time.
With করা আছে তো? The name of the alleged contemner is wrong. It will be Lilima, not Nilima. In your contempt application, you correct that. On the prayer of the learned advocate for the applicant in CPAN 950/2026, leave is granted to correct the name of the alleged contemner. Mr. Twansville, learned advocate appearing for the applicant, petitioner in CPAN 940/2026, submits at 950/2026. Petitioner. Petitioner. 950 প্রাইভেট রেসপন্ডেন্ট অ্যাপ্লিকেশন ফাইল করেছে, তো পিটিশনেরই হলো, পিটিশনে 950 submits as the alleged contemner has not strictly followed the directions issued by this court in its order dated 12th August 2025. No inspection nor any inquiry has been held till date. However, the alleged contemner on 3rd July 2026 has issued a letter observing that the construction made by the applicant, your respondent number, what was your private?
Number
6.
Respondent
In the writ petition, your respond number? Halim Khan.
20.
20.
Your Halim Ali Khan.
Halim.
20.
20. কি বললাম সেন্টেন্সটা? Is illegal and directed for demolition of the same without causing inquiry. Is so and so learned advocate representing the alleged contemner seeks accommodation to take proper instruction let this matter let this matter appear on কোনদিন পরে বলো 15 days এর মাথায় 2 weeks এর ডেট দাও 26 alleged contemner is directed to furnish a report in the form of affidavit on the returnable date. In the meantime, no coercive steps be taken with regard to the notice dated 3rd July 2026. 3rd July 2026 issued by the alleged contemner. You file a report in the form of affidavit disclosing all the facts, and in the meantime, no coercive steps be taken in respect of the notice dated 3rd July. Matter will appear after 2 weeks.
কারেকশনটা করতে হলো ফাইলটা নামটা কারেকশন করতে হলো লিবার্টি বিচ
Next.
লাগলে তো সব জানে
The petitioner before your lordship was a primary teacher, my lord. He was appointed on my lord 1st of November 1990, my lord. My lord, during his service, my lord, he faced a my lord criminal case, my lord. And thus the case is still now pending. But by this time, the petitioner, my lord, superannuated from the service, my lord. My lord, the petitioner approached before this honorable court in several ways, my lord, for my lord getting my lord provisional pension and all these things. My lord, all on occasions, my lord, this honorable court, my lord, passed an order directing the authorities to, my lord, grant provisional pension during pendency of the criminal proceedings. This provisional pension was granted on, my lord, 1st of February 2010, and it continues till, my lord, 31st of January 2012. My lord, thereafter, it has been stopped. And as of date, my lord, the criminal case is still pending, my lord, which is no way related with his service, my lord. If your lordship kindly takes me into the rule 19.5 of the DCRB rule 1981, petitioner is entitled to get provisional pension, my lord, even if the criminal case is pending. My lord, in
No,
similar
this
or
this has been decided by a coordinate bench of this court in page 15.
my lord. My lord,
So
my lord, they
why this
provided.
has been stopped?
Yes, my lord.
That is that you are entitled to provisional pension, that is decided in that order.
Yes, my lord. But it has been given only for 2 years.
Only for 2 years.
2 years.
Okay.
It was granted, my lord, on 1st of February 2010, and it, my lord, ended on, my lord, 31st of January 2012, my lord.
Where it is mentioned that it will be for 2 years.
My lord. My lord, the order sheet I have also annexed, my lord, kindly comes to page 17 once, my lord. I have given the order of the authority.
On page 15.
Page
where is the direction?
Page 17.
No, no. You say that it is for 2 years. Did the court direct that it will be for 2 years?
No, 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 no. There was no such directions, my lord. They themselves, my lord, decided.
Does the rule provide that the provisional?
I could not find anything else from the rule, my lord, 19.5.
Which manual?
My lord, 19.5 says, my lord.
Which book is this?
My lord, Headmaster Manual, Volume 2, my lord.
19.5 of?
My lord, kindly comes to page, my lord, 418. of DCRB rules 1981. Page, my lord, 418, my lord, this 19.5. It says, my lord, final pension, gratuity, etc. shall not be sanctioned to an employee against whom departmental stroke judicial stroke proceedings have been instituted or continued. Stop. In case of misconduct of the petitioner, the pension sanctioning authority has the power to withhold pension or reduce the pension. Where any disciplinary or judicial proceeding is instituted, or where a judicial proceedings is continued against an employee who has retired on attaining the age of compulsory retirement or otherwise, he shall be paid during the period commencing from the date of his retirement to the date on which, upon conclusion of such proceedings, final orders are passed, a provisional pension not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the date of retirement, or if he was under suspension on the date of retirement up to the date immediately proceedings the date on which he was placed on suspension, but no gratuity or death cum retirement gratuity shall be paid to him until the conclusion of such proceedings and the issue of final orders thereon. Payment of this provisional pension shall be adjusted against the final retirement benefit sanction to such employee upon conclusion of the aforesaid proceedings, but no recovery shall be made where the pension finally sanctioned is less than the provisional pension, or the pension is reduced or withheld either permanently or for a specific period. So therefore, my lord, I am entitled to get, my lord, provisional pension. Now, my lord, I shall show to your lordship single bench decision of our Honorable High Court. My lord, I have annexed this order also. My lord, everything has been discussed. In, my lord, kindly comes to page 24 once, my lord.
Yeah.
Page 24, my lord, the geo and everything has been discussed. DCRB rules. My lord, then, my lord, kindly comes to the relevant portion is at page, my lord, 27. Second paragraph. The learned council representing the district primary school council South East Pargana submits that as per provisions of paragraph 19.5 of the DCRB 1981, final pension, gratuity, etc. shall not be sanctioned to an employee against whom departmental judicial proceedings have been instituted or continued. In case of misconduct of the pensioner, the pension sanctioning authority has the power to withhold pension to reduce the pension. Where a departmental or judicial proceeding is instituted, or where a departmental proceeding is continued against an employee who has retired on attaining the age of compulsory retirement or otherwise, Well, this rule has been quoted. Now, thereafter, my lord, it has been already been observed herein above that no departmental proceedings was ever been initiated in this case also, my lord. No departmental proceeding has been initiated against the petitioners, my lord. The only proceedings that is pending is the criminal case that has been filed against him in the year 1991. There is no allegation of misconduct either. This court, my lord,
He
one
was
judgment has
suspended.
been referred.
He was suspended.
Yes, my lord. Initially, he was suspended.
Suspension withdrawn.
No, there is no such order of withdrawal. But he superannuated from the service, my lord, on my lord, 31st of January 2010.
Okay. Yes.
And in this order, my lord, page 28, last paragraph, there is no allegation of pecuniary loss caused by the petitioner during his service tenure. The judicial proceedings which has been referred to in DCRB scheme has to be taken as a proceedings alleging pecuniary loss to the government, financial irregularities, or any illegal act committed by a teacher during his service tenure, which is directly in connection with his service. The same cannot apply in respect of each and every judicial proceedings which has no nexus or is not related with the service of that teacher. Accordingly, there is no reason to withhold the pensionary benefit stroke terminal relief of the petitioner. In view of the law laid down by this court in the matter of Onadi Prasad Mahato versus Gunamoy Mahato, the District Primary School Council, Southeast Pargana, and the District Inspector of School Peace 24 Parganas are directed to take necessary steps to disburse full pension and all other terminal benefits to the petitioner after adjustment of the money which has been paid or received by the petitioner without any further delay.
Yes.
So therefore, my lord, in view of this, my lord, decision as well as, my lord, the DCRB rule 19.5, my lord, I am entitled to, my lord, get the pension, my lord, even if there is a, my lord, judicial proceeding is pending against me which has no nexus with the service of the, my lord, petitioner. My lord.
Now, what is your prayer for release of provisional pension or full pension?
My lord, if we take into consideration of this, my lord, judgment, my lord, I am entitled to full pension.
Yes, let me. Yes, Mr. Prasad.
Your Lordship, the writ petition, my lord, in the prayer that has been, my lord, advanced before this honorable court is for full pension. Now, my lord, my learned friend has, my lord, shown the DCRB provision 19.5. Now, my lord, this subsequently 2009, my lord, for primary school teachers, initially, my lord, this is the only DCRB for school education. And the teachers, non-teaching staffs of primary, secondary, library, everything is covered by this, my lord, DCRB scheme. Now, subsequently 2009, my lord, for primary teachers, a specific scheme has been carved out and it has been notified. This, my lord, particularly, my lord, deals with the teaching staffs of the primary school and the, my lord, non-teaching employees of the, my lord, council. My lord, that is DCRB specifically made for, my lord, says, my lord, West Bengal primary education employees take come retirement benefit rules 2009. It is there in the education manual. My lord will not, I am giving a copy to your lord.
No, this is volume 1.
Yes, volume.
Volume 1 টা নেই আজ কবে এটা পড়ে আমি তো ফেরত দিয়ে দেবো তো পড়ে আমি ফেরত দিয়ে দেবো
Okay.
My lord, first, no, at the outset, my lord, I am showing that
Not teaching.
the DCRB that my learned friend has relied upon, my lord. Then, my lord, I am coming to that. with it.
Yes.
Yes. My lord, 19.5, my lord, as my learned friend has already referred, my lord, I need not to reiterate. My lord, kindly consider Rule 34 of the my lord DCI. It pertains to my lord provisional pension and the time period, my lord, the tenure of provisional pension that has been dealt with. 34, where pension papers are detained for some reason. Provisional pension at the rate of 100% of the pension calculated on the basis of available information and provisional gratuity. After withholding of 10% or rupees 100 of the gratuity, whichever is less, should be sanctioned immediately to the retiring employee of non-government aided sponsor institution organization by the director, consul, or any other officer authorized by him, subject to the furnishing a written undertaking by the pensioner concerned in the enclosed form. In no case, provisional pension, Malik kindly considered, in no case the provisional pension will continue beyond 12 months. Now, my lord, the issue of last pay certificate should not be insisted upon before the payment of provisional pension, but the amount of gratuity withheld will be released only after production of last pay certificate. My lord, this is not required, but the point that I want to highlight, in no case the provisional pension will continue beyond 12, my lord, 12 months. Now, my lord, as I have already, my lord, submitted that in for primary there is a specific scheme has been, my lord, formulated and it has been notified in 2009 itself. Now consider, my lord, that provision of the, my lord, DCRB, my lord, made for primary school teachers.
2009.
2009.
This training institution for primary teachers.
My lord, the very first recitation, my lord, I'm placing in exercise of the power conferred by subsection 1 of section 106, read with clause Q of subsection 1 of section 60 of the West Bengal Primary Education Act, and in suppression of all orders. My lord, got it?
Yes, yes.
All order schemes notification on the subject, the governor is pleased hereby to make, after previous publication, the following rules. The rules may be called West Bengal Primary Education Employees Death Cum Retirement Benefit Rules 2009. My lord, it is in suppression of all previous scheme rules notification. It has been notified. My lord, kindly consider the application portion. That is Rule 2. My lord, the rules shall apply to the employees who have joined the service on or after 1st day of April 1980 and opted for pension cum general provident fund, including family pension and the West Bengal non-government aided educational institution employee death cum retirement benefit, that I have already, my lord, referred before your lordship. 1981 scheme. Those who are there in that scheme, they are also covered by this scheme. And there are employees who have joined, my lord, I am not reading the very first point that I want to place before your lordship. And my lord, kindly come to page 25, Rule 43. Then I am coming to the provisional pension provision, my lord, incorporating the provision. Rule 43, kindly consider for once. My lord, the provision of West Bengal recognized non-government educational employees death cum retirement benefit scheme 1981 as applicable to teachers of primary schools, along with notification memorandum and orders published earlier relating to the eligibility, application, admissibility of the benefits under the aforesaid West Bengal recognized non-government educational institution death cum retirement benefit 1981 shall be deemed to have been repealed insofar as they are repugnant to the matters covered by these rules. Therefore, my lord, it is specifically, my lord, for keeping in mind the teachers and the employees of the council, my lord, governing under the, my lord, primary educations. And those who are in DCRB also, they are coming under this provision. Now, my lord, kindly consider the relevant provision with regard to, my lord, when against a person a judicial or departmental proceeding is pending, what will be the fate? And, my lord, judicial proceeding involving moral turpitude. What is the fate? What is the effect of that provision in the event of continuation of pension? Now, kindly consider the very first thing, I want to point out. There is no dispute to the issue that pension is a deferred payment or it is not a bounty. But the fact is that the eligibility for pension or the continuation of pension, payment of disbursing of the pensionary benefit after according the pension, it always depends upon the rules of DCRB and the provision of the DCRB. Continuation is always depends upon it. Kindly consider now kindly first consider rule 16, rate of pension. Rule 16, your lordship. Rule 16, I am not reading the entire rule, but the relevant provision, kindly consider rule 16 sub rule 8, 9, 10.
Yes.
8 is that service of an employee against whom a charge of corruption has been initiated through proceeding cannot be considered to be satisfactory. Rule sub rule 9, final pension gratuity shall not be sanctioned to an employee against whom departmental or judicial proceeding have been initiated and pending. Final pension, here the prayer is for final pension. Final pension, gratuity, etc. shall not be sanctioned to an employee against whom departmental or judicial proceeding have been initiated and pending. In case of misconduct, sub rule 10, in case of misconduct of the pensioner, the pension sanctioning authority shall have the power to withhold pension or reduce the amount of pension. Now kindly consider rule 18 onwards. It was elaborated. It has been elaborated, provisional pension, where any departmental or judicial proceeding is instituted and pending against an employee who is allowed to retire on attaining age of superannuation or otherwise, he shall be paid a provisional pension following his prayer during the period commencing from the date of his retirement to the date on which the final order are passed by the appropriate authority on such proceeding. Where an employee who is allowed to retire on attaining age of superannuation but whose pension has not been sanctioned by the pension sanctioning for want of necessary service record shall be paid provisional pension for only 24 months from the date of retirement following his prayer. 24 months. Now, the next one, the amount of provisional pension shall not exceed the sum total of maximum amount of pension and the maximum amount of dearness pension, which would have been admissible to an employee on the basis of his qualifying services up to the date of retirement, or if he was under suspension on the date of retirement up to the date immediately preceding the date on which he was placed on suspension. Now, sub rule 4, payment of provisional pension shall be adjusted against the final retirement benefits sanctioned to such employee up to the conclusion of the aforesaid proceeding, but no recovery shall be made where the pension finally sanctioned is less than the provisional pension or the pension is reduced or withheld either permanently or for a specified period. Sub rule 5, during sanction of provisional pension under this rule, report of admissibility of pension is required to be obtained from the Director of Pension, Provident Fund and Group Insurance, West Bengal. Such provisional pension shall be subject to adjustment against all amount of pension, including gratuity or by short payment of pension. All outstanding dues shall be adjusted in the same manner as above. Now, rule 19, also very important. Here, the rule is more in a very detailed way. It has been elaborated. Rule 90, right to withhold pension in certain cases. My lord, kindly consider the pension of an employee may be withheld or in whole or in part under an order of pension sanctioning authority passed not later than 3 years after the date of retirement to meet any sum under the liability incurred by such employee to the respective district primary school council or board. The pension sanctioning authority reserved to himself the right of withholding or withdrawing a pension or any part of it, whether permanently or for a specified period, and the right of ordering recovery from the pension relief of the whole or part of any pecuniary loss caused to the government if person is found to have been guilty of grave misconduct or negligence during the period of his service, including service rendered or re-employment after retirement. Provided that such proceeding by the managing committee be instituted while the employee was in service, whether before his retirement or during re-employment, shall after the final retirement of the employee be deemed to be a proceeding under this article and shall be continued and concluded by the authority by which it was commenced in the same manner as if the employee had continued in service. Allotted, provided further that such proceeding, if not instituted while the employee was in service, whether before his retirement or during re-employment, shall not be instituted, save with the sanction of Secretary of Department, and shall not in respect of any event which took place more than 3 years before such institution. Allotted, thereafter, sub-rule 3. Now, this is very important. Malote, an employee who retired from service but against whom criminal proceeding involving moral turpitude is pending in court of law shall not be sanctioned any pension until termination of the criminal proceeding. Here, in this case, against this petitioner, Malot, immoral trafficking charges under the Immoral Trafficking Act is pending. Now, Malot, provided that an interim allowance, kindly consider, not exceeding 2/3 of the pension that would have been admissible but for the criminal proceeding may be granted during the pendency of such proceeding in case of hardship. Maximum this can be entitled because in case of any criminal proceeding, having a color of moral turpitude, we cannot disburse the full pension. The permissible benefit that can be given in that circumstances is only
2/3.
Interim allowance.
2/3.
2/3.
2/3 of the pension.
2/3 of the pension. Now, Malota, provided further that if he is convicted on a criminal charge involving moral turpitude, he shall not be entitled to any pension, but a compassionate allowance may be granted to him, and this shall not exceed 2/3 of the pension which would have been admissible to him if he had retired on medical certificate. It is after the conclusion of the criminal proceeding, and there was a finding that yes, moral turpitude is very much involved. Then, Malota, what would be the relief that this type of person will get? Malot, it is compassionate allowance. Provided also that interim allowance or compassionate allowance, as the case may be, can be sanctioned only after obtaining an admissibility report from the Director of Pension Provident Fund and Group Insurance, West Bengal. Provided also that no such judicial proceeding, if not instituted while the employee was in service, whether before his retirement or during his re-employment, shall be instituted in respect of a cause of action which arose or an event which took place more than 3 years before such issue. This is not relevant. Therefore, thereafter, when the judicial proceeding has been initiated, departmental proceeding has been initiated, explanation 1 has been mentioned. The time to be treated at the initiation of the departmental proceeding, thereafter judicial proceeding in the nature of criminal as well as civil, both have been incorporated. Now, the subpara 4 also kindly consider. This is the most elaborated provision, everything has been covered. Wherein department of judicial proceeding instituted against an employee who has retired on attaining age of retirement or otherwise, he shall be paid during the period commencing from his retirement to the date on which, upon conclusion of such proceeding, final orders are passed, a provisional pension not exceeding the maximum pension which would have been admissible on the basis of his qualifying service up to the date of retirement, or if he was under suspension, for the period between the date of his joining to the date immediately preceding the date of suspension, but no gratuity or death cum retire gratuity shall be paid to him until conclusion of such proceeding and the issue of final orders thereof. My lord, the judicial proceeding or the criminal proceeding not involving moral turpitude. What would be those cases? What will be the provision? This is sub-rule 4. My lord, rule 5, sub-rule 5, provisional pension made under sub-rule 4 shall be adjusted against final retirement benefits sanctioned to such an employee upon conclusion of the aforesaid proceeding, but no recovery shall be made where pension finally sanction is less than the provisional pension or the pension is reduced or withheld either permanently or for a specified period. My lord, rule 20 is also there. Withholding of pension or denouncement in case of conviction and misconduct. What would be the effect if the criminal trial is, my lord, culminated in conviction and misconduct? This has also been, my lord, dealt with in this rule 20. Now, my lord, therefore, in the case of the petitioner, my lord, the criminal case, judicial proceeding, my lord, in the nature of criminal case that is pending is immoral trafficking. Therefore, my lord, maximum he can get is the, my lord, interim allowance, my lord, that I have referred, rule my lord 19(3). Compassionate allowance. Sorry, your lordship, this is the interim allowance. Interim allowance. And in the event of, my lord, conviction, compassionate allowance. And in case of, my lord, provisional pension, what is the time period? My lord, the time period for, my lord, continuation of that pension is 24 months. That I have, my lord, also referred.
So what is the distinction between 18.2 and 18.2 and 19.4?
Yes.
What is the distinction? In 19.4 it says that provisional pension, it does not specify for which period.
Yes.
What is the difference?
My lord, rule 18.2 18.2 says, my lord, kindly consider the pension sanctioning authority is not able to process the pension because of, my lord, for want of necessary service records. Rule 18.2.
Want of necessary, okay.
Yes. In that event, 24.
It is full pension.
19.2, 18.2.
18.2.
In his case, you have not got the service records.
My lord, what I am on, my lord, what it appears from that 2 years, after 2 years, it has been stopped. Now, my lord, what I am, my lord, from the my lord, reading of the entire petition, my lord, what I am understanding, provisional pension should continue. I have, my lord, asked for instruction why it has been stopped, because the pension sanctioning authority is the, my lord, DI of school. DI of school, and he is the, my lord, ex officio secretary of the council.
But then in his case, if it is immoral trafficking, then 19.3
Yes.
will operate.
Now, this is the now, as he in this case, the criminal case that is pending, my lord, it is having a, my lord, color of, my lord, involving moral turpitude. In that event, my lord, 19.2 is the specific provision which will govern the case of the petitioner. In interim allowance, 2/3 of the pension. My lord, because
what is your instruction? You have,
my lord, I am yet to get the instruction. With regard to my lord, his prayer for final pension, that under the provision of the DCRB is not, my lord, at all, my lord, permissible. And the judgment that my learned friend has cited, that my lord, in case of pecuniary loss or if it is not there, final pension has to be given. That the ruling that has been relied upon therein, my lord, those ruling has been, my lord, repeatedly, my lord, subsequently coordinate bench has taken note of, has deferred, because it is contrary to the Supreme Court decision. Supreme Court has said pension, it is not a bounty, no issue. But the payment of pension or the continuation of pension is always depends upon the pensionary scheme, the condition of the pensionary scheme. In one of the case, my lord, similar contention was raised, that is, it is not related to any pecuniary loss or anything. Government has not suffered any pecuniary loss. Why final pension will not be given? Supreme Court has negated that contention, says, now only entitlement, you are entitled for provisional pension. If my lord want to see that judgment, my lord, I can show to your lordship. This is, and our coordinate bench has also dealt with that is, my lord, 1995 6 SCC 105. This is State of Odisha versus Kalichara Mahapatra. Similar contention has been raised. It is coming from a Central Administrative Tribunal order. It has been challenged in the Supreme Court by the authority concerned. Here the applicant was a central government employee against whom a charge of prevention of corruption is there. They have not released the final pension. He has made a prayer to the tribunal to release the final pension. The order has been passed in his favor. It was challenged in the Supreme Court, and Honorable Supreme Court has dealt with that particular provision. Will consider paragraph 3 onwards. If Malot will say that I can place, because here this particular issue has been dealt with. The respondent was a member of Indian Police Service. He retired on 31st of December 1990. About 6 months prior to his retirement, a raid was conducted on his residential premises. On the basis of material recorded, a prosecution has been launched against him in the special court Kotok under Section 13(2), read with Section 13(1) of the Prevention of Corruption Act for being possession of asset disproportionate to his known source of income. Now, the case is still pending. In view of the pendency of the said criminal case, the appellants withheld gratuity amount, did not also sanction the pension finally. A provisional pension equal to 90% of his entitlement was, however, sanctioned. Aggrieved by the refusal to release the gratuity amount and the refusal to sanction his pension, finally, the respondent approached the tribunal. Malota, the DCRB has been quoted. Now, Malota, similar pari-materia with the pension scheme that I have referred to your lordship and the pension scheme of the education department. Pari-materia provision. Malota, may I read this, Malot? Malota, the appellate
intend to file any report or
yes,
instruction?
let it be there, because
with the reason that why that has been stopped.
Yes.
If
that
you say that 19(3) applies in his case,
yes,
then also he is entitled to.
For
he says 2012.
There is no quarrel to that.
2012.
Yes.
Even if, for the sake of argument, we consider that this relates to moral turpitude.
Yes.
Then also, since 2012, he is entitled interim allowance.
Yes.
That's 2/3 of the pension. Even if not final pension, then interim allowance
Yes,
is.
it should be. It should be, Malot, to that effect. If he is insisting on final pension, Malot, then
let it be disposed of with a direction to Milord issue Milord in terms of Milord 19(3).
What is your submission to that?
My lord, I am leaving to your lordship, my rather a report to be called for, my lord, then let it be decided.
It's my learned friend accepting I am entitled to interim, Milord, interim measure.
It is my submission, not my
submission is, Milord.
But what I am on, my lord, from the entire DCRB.
Submitting on behalf of the authority, you are saying that I am entitled to get,
yes,
even if a rule says also that I am entitled to get interim maintenance,
interim decided, because
amount during pendency of a judicial proceedings.
Affidavit of service filed on behalf of the petition is taken on record. Mr. Malay Bhattacharya, learned advocate, by the present writ petition, the petitioner seeks for grant of family full pension, grant of full pension in favor of the petitioner. Mr. Malay Bhattacharya, learned advocate for the petitioner, submits that the petitioner has been granted provisional pension pursuant to order passed by this court in WP number 1789W of 2010, and the same has been continued for 2 years.
From Milord, 1st of February
From
2010
1st of February 2010
to Milord 31st March 12.
31st March
Sorry,
2012.
31st January 2012.
31st
years.
January 2012.
Yes.
No, 1st February 2010 to 31st January 2012. 2012. No such provisional pension has been granted thereafter. The petitioner relying on a decision of the coordinate bench in WPA 6171 of 2022, Sri Sukhdev Haldar versus State of West Bengal and others. He submits that since the offence of the petitioner had no nexus with his service, and there is also no allegation of pecuniary loss to the government by the petitioner during his service tenure, the terminal benefits of the petitioner should not be withheld by the authority concerned. Mr. Para Abhishek Prasad, learned advocate representing DPSC Malda, submits that the petitioner has been the petitioner has been charged with the provisions of Immoral Traffic within bracket Prevention Act 1956, which is directly related to moral turpitude. As per Rule 18(2) of the West Bengal Primary Education Employees within bracket Death cum Retirement Benefit Rules 2009. The provisional pension has been granted to the petitioner only for 24 months. Rule 19 of the rules of 2009 authorizes the pension sanctioning authority to withhold pension in certain cases, particularly when a criminal proceedings involving moral turpitude is pending in a court of law. He seeks to furnish a report. Let such report be filed within a week. He also relies on the decision of Honorable Supreme Court in State of Orissa and others versus Kalicharan Mohapatra and others, reported in 1995, Volume 6, SCC 105. Placing reliance on such and such decision, he submits that the pension sanctioning authority is bound to act in terms of the rules framed in the subject. Next week, you top of the ground.
Yes.
Next week, you file your report.
Next.
ফার্স্টের দিকে রাখবো।
Eighteen.
Can it
I am
be,
appearing on
Malord, only one prayer, Malord. Can it be, Malord, the 19, Malord?
19th.
Yes, I, 89.
Where is Mr. Bhattacharya? 19th, then it will go to the other week. Next week then.
Next week.
18th তো 18th এর পরে
89,
19th August.
18th এর পরেরটা কি আছে বলো 25th.
25th. No.
Ask Mr. Bhattacharya to go.
Yes, I am informing him. I am.
18th he has some problem. I'm placing it on 25th.
25th, no, please.
Oh.
25th I don't have. No, my lord, this is a matter relating to, my lord, conversion from CPF to GPF.
Huh?
Yes.
Conversion.
Yes. Exercising option after.
Where is the document that he has opted for
My lord,
1990?
yes, yes. That is, my lord, kindly cease page 16 to 20 of the writ petition once. My lord, there was a confusion because lordship may kindly seize the geo number 33 EDN 73/1990. The teachers, the finance department notification has been adopted by the education department by way of this particular notification. Lordship may kindly see. So the petitioners, the teachers has to exercise option in terms of this memo. This is the memo, my lord. My lord, take to page 160 ta there.
कोई की manual, headmaster's manual, volume 2, page number 160. What do you think?
Second time. Passover. My lord, my learned friend is seeking.
My lord, I am playing for a short passover.
My lord.
Who will appear?
Loknath Chatterjee. My lord, it's in the Loknath Chatterjee. My lord can fix it for 2 p.m. at 2 p.m. today.
No, ask him to come 10 minutes Passover.
My lord.
You report they have filed.
Yes, my lord, report they have.
Ask him to come.
I am for the petitioner, my lord.
My lord, matter is widow daughter family concern. The petitioner
Father retired on 15 December 1983.
No, what is the prayer?
My lord, here is
Family
page number
pension.
15, my lord.
Lived 60 years and he died. Right.
And for the statement, but the page 16 annexed P6, this is undated representation. Kindly see, man.
My father enjoyed pension. Remember, my mother was getting like was given a father's pension. And no social. Unmarried daughter.
Widow daughter, my lord.
Widow daughter. You have not stated. In your representation, page P6, you have not stated that your widowed daughter. In your repetition, you have stated.
Yes, my lord.
Which paragraph? Father, this.
My lord, paragraph 6.
6. deceased father. Where is the death certificate of your husband?
My lord, page 15.
Roll. Oh, বলবো না তো। No, no, in which place you have stated that your husband so and so has expired on such and such day? Which place?
My lord, page number 15. Death certificate.
Page number 15 is a date
yes, yes.
certificate, one Parashuram Mondol.
Yes, my lord.
What is his name? Page 5. Paragraph 5. Paragraph 5.
Husband of the
Anshura
petitioner named
Mondol, unemployed at no sir.
Vanchuram Mandal.
Husband died on 19/1. Yes, 13. When did you file the application?
My lord,
Let him file an
January.
application, comprehensive application before the authority for due consideration.
my
Affidavit
lord, as per my instruction, my client, the concerned authority did not give in receipt copy.
Why didn't you send it by post?
Speed post or any other way.
You file it within a period of 4 weeks. File a comprehensive application, annexing all the documents. Let them decide on such application.
Yes, my lord.
Give the affidavit of service.
Yes, sir.
Affidavit of service filed on behalf of the petition is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly respondent number 3, 4, and 5, to disburse family pension in favor of the petitioner. The petitioner contains that her father, late Toilendranath Samanto, was a head teacher of Tulsi Ghata FP Primary School
Under Joynagar Circle.
Under Joynagar Circle. The petitioner's father, after discharging his service for 33 years, retired on superannuation on 15 December 1983. Pension payment order was issued in favor of the petitioner's father on 23rd February 1990, and the petitioner's father was granted pension. The petitioner's father died on 19 December 1995. Upon demise of her father, the mother of the petitioner, namely Subhadra Samanto, also received pension during her lifetime. The mother of the petitioner died on 7th February 2014. 7th February 2014. The petitioner's husband died on 19th January 2013. The petitioner is the widowed daughter of the deceased employee. The petitioner submitted representation for grant of family pension, however, the same has not been considered, hence this writ petition. Mr. So-and-so, learned advocate for the petitioner submits that the respondent concerned authorities, concerned respondent authorities be directed to take, that will consider the representation of the petitioner. Mr. So-and-so, learned advocate paragraph. For the state submits that the representation of the petitioner is undated. Representation of the petition is undated and there are no documents that the same has been received by the office of the District Inspector of Schools P South 24 Parganas. To this learned advocate for the petitioner seeks leave to furnish a comprehensive representation before the authority concerned. In view of the submissions advanced, leave is granted to the petitioner to submit a comprehensive application before the. This will be District Inspector of Schools, respond number 3. District Inspector of Schools P South 24 Parganas within a period of 4 weeks from date. Upon submission of such comprehensive representation by the petitioner within the prescribed period, respond number 3 shall consider and dispose of the same in accordance with law or notice to the petitioner within a period of 8 weeks from date of submission of such representation. The reason and pass a reasoned order. The reasoned order shall be communicated to the petitioner within a period of 1 week of passing thereof. Within 4 weeks, we file that. After submission, 8 weeks.
Grateful.
Yes, madam. Grateful.
God bless.
Yes.
I'm staying for Passover, madam. My senior man, Kollan Kumar Pandey, engaged in code number 24, madam. I am Passover.
Passover.
My lord, I am for the petitioner, my lord. Widow daughter, family pension, my lord. Petitioner father died in harness, my lord. Petitioner father was a primary teacher, died in harness in the year 1970, my lord. Thereafter, petitioner mother get the family pension in the year 2012. Her mother also died in the year 2014, my lord. Petitioner paid family pension, but that was not considered.
When did you file the application?
My lord, page 19, my lord, 17/11/2025. Age 90.
2025. When did the mother die?
2014, man.
After 10 years.
Yes, my lord.
Why?
My lord, the widow pension case was not known to the petitioner, my lord. After the special bench judgment, she came to know that similar candidate get the pension.
Mother died in 14.
Yes, ma'am.
Which paragraph? 14.
Page 17, my lord, death certificate of the mother.
Will appear for the state in this matter?
Here, my lord, instructions have been obtained, but my lord, perhaps there is some issue as to whether who's been formally appointed. That I think, my lord, should not be an issue in my lord taking up a matter, my lord. My lord, here the main issue is, my lord, the father of the petitioner died before DCRB 81. So whether, my lord, dependent family pension, my lord, is to be entitled, my lord, under the 81, my lord, DCRB, that, my lord, is.
But the larger bench decision says so that.
That is, my lord.
As well, larger bench.
There is a representation will be considered in accordance with law.
Yes,
But they applied for dependent family pension, my lord, in November 2025, my lord. My lord,
November
and father
25.
died in 1970, my lord. 14 January 1970.
That I've seen. Mother has died on 14,
Yes.
2014.
Yes,
So there is
November 2014, my lord.
$1998. Did the authority decide on the application?
Yes, that, my lord, I believe.
If there is delay or anything of that sort, if
Yes, yes,
he or
they will
she is
let them
entitled to that, they can decide on that.
At least a representation be considered, but that can be done.
Affidavit of service filed on behalf of the petitioner is taken on record. The petitioner contains that the father of the petitioner, late Shatrughna Hajra, died in harness on 14 November 1970. Sorry. The father, late Shatrughna Hajra, was an assistant teacher in Kolabedia Board Primary School, post Kolabedia, Bhagawanpur district, Purbo Medinipur, who died in harness on 14 November 1970. The petitioner's mother was granted pension. Where is the PPO?
Yes, my lord. PPO P2, my lord, annexed P2.
Page 15, my lord.
Page P2.
Yes, my lord, page 15, my lord. Base copy 15A, my lord.
You find out.
My lord.
Did you find from the PPO that she was granted pension or she was receiving just the gratuity? Or
Larger bench can also be, my lord, to that extent distinguished. But I'm not going into that, my lord, because larger bench, my lord, essentially said, my lord, who retired or died in harness prior to 1/4/1981. So, my lord, here the person, my lord, unfortunately, my lord, passed away in 1970, my lord. So, my lord, it died in harness, chilo.
died in harness, but the PPO at
lord.
page 15,
My
the
lord.
typed copy is 15A. It does not record of any amount of pension. What is the amount of pension that she was receiving? Nil. See over here, there is a column 6 capital A.
My lord.
Pension with effect amount rupees nil. See, the mother was not receiving the pension. Whether the widowed daughter will be entitled to pension or not.
My lord, perhaps, my lord, although this is, my lord, come much later, this is a memo of 2012. My lord, I believe, my lord, it could also be the case that she had received other pensionary benefits. It could also be that case.
So
my
you
lord,
come up
because-
with a report. You get a report.
Better, my lord.
Yes.
My lord,
Mr.
My lord, I have,
my lord,
the report
instruction.
is there, but it's scanty, my lord, because it's একবার judge সাহেবকে দেবেন? It is, my lord, not a very detailed report.
Column 6. My lord, column 6 kindly see.
Yes. Column 6.
As per their as instruction, my lord.
Oh.
Real 6, my lord.
Remaining family pension for those receiving employees belong to DCRB to fees 21. Not entitled to that. এটা জিজ্ঞেস করতে এই যে জিও নাম্বারটা আছে কিসে থাকবে হেডমাস্টার্স ম্যানুয়াল না এডুকেশন ম্যানুয়ালে ওনাকে জিজ্ঞেস করো না মিস্টার চ্যাটার্জি
My lord, that geo is annexed in the repetition, my lord.
Annex?
Yes, my lord. Page 30.
30?
Yes, my lord. 1-3. P1.
Pension, no, pension, yeah. But it should be, my lord, of the
widow divorce can apply to the middle that can return to
my lord, that is page 624. 624, volume 2, my lord.
Volume 2 of the headmaster's manual.
My lord, my lord.
624.
My lord, that's what I believe. 96 SEB, my lord. এটা জজ সাহেবেরই কপি, ওনাকে দিই। আমাদের কাছে একটা কপি আছে।
ও 624 নয় তো এটা
624 towards the bottom of the page, my lord. ও এটা ম্যাচ করবে না মনে হয়, নতুন বই জজ সাহেব।
not this one.
এটা দিন।
Which one? There was a geo. If a person dies prior to 1981 scheme being framed.
My lord, sees that, my lord. একটু জজ সাহেবের বইটা দেবেন, আমি বার করে দিই।
দিয়ে দাও
আমি বার করে দিচ্ছি।
My lord, special bench judgment, it was quoted, man. That geo is quoted here.
হ্যাঁ, এই যে
স্পেশাল বেঞ্চ জাজমেন্টে উল্লেখ আছে।
ওটা কোট করা আছে।
হ্যাঁ।
দিয়ে দাও বইটা। You are carrying that judgment?
Yes, ma'am.
Paragraph 18.
Paragraph 18 and 19, my lord, it was clearly stated that petitioner is entitled.
Teaching and retired prior to 1981 or after. You have seen that para 18 of that.
I have seen, yes, my lord. I was just able to, my lord,
Probably the circumstances prior to and after remains the same.
both are covered.
Remains the same.
Both are covered. My lord, unaltered have
Contradiction.
that non-teaching staff who retired prior to 1st April or after
Yes.
was entitled to get pensionary benefits in terms of the DCRB scheme 1981. On
as
demise
per-
of such staff, their widows are entitled to get family pension in terms of modified provision. With a memorandum of 1st November 2010. My lord, 1st November 2010, my lord, is the one quoted here in this judgment also, my lord. My lord, the one which we were referring to is of 13th April 2010. At page 568 of my lord's book. The unmarried or widowed or divorced daughter of an employee retired prior to 1st April 1981 or after 1st April 1981 is entitled to get family pension on fulfillment of requirements as per the mechanism introduced with a memorandum number such and such dated 13th April 2010. The one which I was referring to. Plus legal scenario, we do not concur with the decision. Belarani Atharjo.
So I think clause 7 of the report will not apply. Because he says that since he died prior to introduction of DCRB 81, so she is not entitled.
Yes, but my lord, 13th April. Yes, but my lord, 13th April 2010, my lord, subject to the other conditions which are there, my lord. My lord, so my lord, essentially, my lord will be pleased to take my lord 13th April 2010 memo. My lord will be also be pleased to take my lord. My lord will flip through a few pages. My lord, 1st November 2010, which my lord, which is quoted in this my lord special bench judgment, my lord. The 1st November 2010.
First November, yes.
That is quoted. Then my lord will be pleased, my lord, my lord will be pleased to take the book, my lord. My lord has 13th April 2010 in front of my lord, page 568 of my lord's book.
Yes.
My lord is 13th April. My lord flips a few pages. The next memo, my lord. My lord, I'll just give the relevant memo numbers, my lord. Dates.
539.
Then 539, my lord, which is 1st November 2010, my lord. That is in the special bench, my lord. Then my lord will please to take 12th July 2011, my lord. 12th July, my lord, 883, my lord. So, my lord, these are the three relevant memos, my lord, which my lord will be pleased to consider. My lord, should I place 13th April, my lord?
Need not, because special bench says that the circumstances for the teaching and non-teaching staff remains the same. They will be guided by DCRB scheme of 1981, subject to fulfillment of the requirement under the memo 13th April 2010.
Yes, yes. But my lord, here, my lord, in this case, this was more effectively, my lord, a decision, my lord, of overruling Belarani Acharjo, unmarried daughter. That is the special bench has the effect. But my lord, here, whether my lord, the dates in this case the relevant dates 1970, 81 DCRB, 2014 death of the wife, and then application made in 2025. So these are the three relevant dates. But considering these dates, whether
No. Let the authority decide on the application of the petitioner in terms of the orders passed by this court.
Also, in case I do not want them to come up on another round of litigation, maybe please, also to give them the guidelines, consider these guidelines and decide. Otherwise, this leads also to a problem for the petitioners, and everyone.
Okay, I quote this particular paragraph 18 of the larger bench decision. In light of that,
And
they
the
are
relevant,
said.
they will,
Yes.
so that it's
Because it also specifies 13th April 2010, which is to be followed, because until and unless that's conditions are met,
yes,
then they cannot
November
get the
2010 is
yes
there, but it 13th April 2010 conditions have to be met.
That has been
November
categorically stated.
2010 is to be read with 12 July 2011.
Yes.
12 July 2011 was only on the the limited point, of what is the date of effect, after the governor has been pleased to direct pension sanctioning authority that the benefits under the 1st November 2010 shall be given to retired living employees as a social security measure as per terms and conditions contained with effect from 1st April 1981 or from the date following the date of retirement of employee, whichever is later. The benefits of family pension as a social security measure under GO of 1st November 2010 shall also be given to the living spouse of the deceased employees as mentioned in such and such with effect from 1st April 1981 or from the date following the date of the death of the employee, whichever is later. In case where PPOs have already been issued following 1st November 2010, revised PPOs shall be issued by the pension payment authority to give further effect in terms of the memorandum. So,
yes, I think 18 will suffice all the
yes,
issues.
yes, yes.
Asun, affidavit of service filed on behalf of the petitioner is taken on record. By the present writ petition, the petitioner seeks direction upon the respondent authorities, particularly responding authorities to grant তাহলে কিভাবে হবে? এটা ডিপার্টমেন্টে যাবে তো, এটা ডিপার্টমেন্টে করতে হবে তো, ঠিক।
ঠিক আছে।
অ্যাপ্লিকেট সাইডের রুলসে কি আছে? Who will correct this teaching? As per appellate side rules, who will correct this teaching? This year fine without proper teaching. ওটা ঠিক করে তারপরে প্লেস করবে। Learned advocate for the petitioner is directed to correct the page number 10, teaching of page number 10. কি করবো, ওটাকে অ্যাপ্লিকেট সাইডে করে দেয় ওরা ডিপার্টমেন্টে? না, অরিজিনাল সাইনের মধ্যে কিছু নেই তো। Affidavit of service filed on behalf of the petition is taken on record by the present petition. The petition seeks direction upon the respondent authorities to grant family pension in favor of the petitioner. The petitioner contains that her late father, Shatrugana Hajra, was an assistant teacher who died in harness on 14th November 1970. Was an assistant teacher, in Kolaberia Board Primary School, post Kolaberia, Bhagwan district. আগে বলেছিলাম। The petitioner's mother pension was sanctioned in favor of the petitioner's mother. on 22nd March 2012. The mother of the petitioner died on 6th November 2014. The husband of the petitioner died on 1st July 1998. On 17th November 2025, the petitioner made a representation before the authority consents for grant of family pension. However, the same has not been granted, hence this writ petition. Mr. Dilip Kumar Sadhu, learned advocate appearing for the petitioner, submits that the matter be dedicated to the appropriate authority for due consideration of the representation of the petitioner. Mr. Loknath Chatterjee, learned advocate for the state, submits that the father of the petitioner has died on 14th January 1970. Died in harness. Prior to the introduction of DCRB's 1981 scheme, death come retirement benefit.
My lord, I'm sorry, my lord. My lord, please to observe, just died. I do not have instructions that he died in harness, my lord.
Died on prior to introduction of DCRB 1981 scheme. However, he concedes that the matter be relegated to the appropriate authority to decide on the application of the petitioner in the light of the decision rendered by the larger bench in State of West Bengal and others versus Sobita Roy, MAT 1518 of 2019. In Sobita Roy Supra, the larger bench observed in para 18 to set out for considering the submissions advanced on behalf of the respective parties, the district inspector of schools P is directed to consider the representation of the petition in the light of the decision of the larger bench rendered in Sobita Roy Supra. Upon notice to the petitioner and pass a reasoned order in accordance with law, the reasoned order shall be communicated to the petitioner. Disposed of. এটাকে ঠিক করে দেবে. Leave granted to correct this teaching. একটা পাস ওভার আছে না 12
But in this matter, my lord. আচ্ছা এটা বইটা সরিয়ে দিচ্ছি
12
my lord, it had fallen from my lord on the last occasion as to when, on what date, my lord, they made the application.
Exercise of option as per ROPA 1990. Well, I was inviting your lordship's attention to page 16 to 20 of the writ petition, my lord. The specific memo number, that is 33 EDN B73 1990. Your lordship will find that at the top of page number 60. My lord, yes, the education department adopted the notification of the finance department regarding ROPA via this memo, and under this the teachers have exercised their option. This is there, my lord. Page 16 to 20 of the writ
of the
petition.
headmaster's manual.
Yes, my lord, page 160, volume 2. Lordship may kindly consider this memo. Under this memo, the teachers have exercised option. And once they have exercised option, as per ROPA 1990, subject to your lordship's approval, there are decisions of the division bench of this honorable court, as well as your lordship and coordinate benches, that the petition, in case writ petitioners, or in case they are deceased, they are widow, they are entitled to get the benefit of conversion from CPF to GPF. That is settled, my lord. This is the memo.
This is in respect of ROPA 1990.
Yes, my lord, this is the memo. That was creating confusion. So now your lordship will kindly seize page 16 of the writ petition once.
এই মেমো নাম্বারটা বলো
Dada. Geos 33 EDN 73 1990, volume 2, page 106. করবে না আচ্ছা ঠিক আছে হ্যাঁ 160 আমার এটা
নতুন বই
দিচ্ছি Ish. Now, 16 onwards. Form of option, Annexure 8B, page 18, my lord. And then page 19, option form. Your lordship was already putting this question to me whether he has exercised option or not. Now, probably the confusion is clear. He has exercised option as per ROPA 1990.
Okay. Yes, Mr. Chatterjee, we can dispose it off.
Mike.
By the present writ petition, the petitioner seeks permission to deposit the employer's share of contributory provident fund together with the interest and additional interest in order to avail the benefit of family pension. The petitioner contains that এটা দেখে নেবেন আগে যেটা করেছি ওটা থেকে দেখে নেবেন কোন কোন অথরিটি ক্যালকুলেট করবে contains that her husband late Aurobindo Das was an assistant teacher of Raghunathpur FP School District South 24 Parganas who retired on service on superannuation, retired from service on superannuation on 30th November 2001. The petitioner's husband died on 17th November 2014. The husband of the petitioner exercised option under ROPA 1990. The petitioner seeks to deposit the employer's share in contributive provident fund in order to avail the benefit of family pension. Rest same submissions. Will calculate, and district inspector of schools is directed to calculate the amount to be deposited by the petitioner. Upon intimation, the same shall be deposited by the petitioner. Upon such deposit, the DPPG respondent number DPPG is respond number?
My lord, respond number 3.
3 shall issue grant family pension in favor of the petitioner. The pension shall be given effect from the date of death of the husband of the petitioner, that is 17th date following the date of death of husband of the petitioner. Disposed of.
My lord, the process may be completed within a period.
The process will be completed within a period of 8 weeks from date of communication of.
My grateful. Grateful.
14.
My lord, kindly taken up, my lord, 2 p.m., my lord. Kindly taken out 2 p.m.
But here, my lord will be pleased to direct.
Senior Kollan Kumar engage code number 24, my lord.
Nobody is there for the petitioner to argue.
Is my lord will be pleased to direct me to file a report, my lord, because I will, my lord, here, interestingly, my lord, the heirs have come.
No, there was a direction to the state to furnish a report.
There was a direction. No report.
Not today, Kado. I'm making it not today, you come up with a report.
Right.
In the coming week.
Because, my lord, here it is not, my lord, a very clear case, my lord.
Line add go. Mr. Loknath Chatterjee, learned advocate for the state, seeks extension of time to file report. Let such report be filed on the returnable date. Advance copy be served upon the learned advocate for the petitioner. Next week you can file that. Next week.
My lord, gives me a bit. कौन है इसमें? हाँ? कोई है, लेकिन report मंगवाना पड़ेगा.
69 for the petition. The one of the affidavit of surplus. But the father of the petitioner was the employee
of the primary school, my lord. He's the primary teacher in retired from service, and subsequently thereafter, my lord, the pension payment order issued. My lord, kindly see page 13. Page 13, my lord.
13.
Yes, page 13 is the pension payment order. Top my memo number and my lord, date is 31st January 17. Top left side corner, my lord.
31st January 17.
Yes, my lord. And my lord, the father of the petitioner was died in my lord, 24th January 2018. Page 12, my lord. The date of date is recorded, my lord, the 24th January 2018.
Which paragraph?
My lord,
24 January.
page 12. And the petitioner is the, my lord, the divorcee daughter, my lords. My lord, the district magistrate issued the memo of legal year certificate for the getting the pensionary benefit. Page 14, my lord. Kindly see page 14. Page 14. First, my lord, Moumita Koviraj. This certificate is for the getting pension and death benefit. My second paragraph, the order, my lord, kindly page annexure P2. The serial number 1, Moumita Koviraj Dotto, my lord, the age 36, daughter, divorcee, sir, recorded, my lord. She applied for, my lord, the family pension. And my lord, the family pension order was issued in favor of her. Page 18. Pension payment order in favor of the my lord, Moumita Koviraj. Is the petitioner herein. My lord, kindly see top, the date is 29th September 2020.
Yes.
And column 8, the name of the petitioner, Moumita Koviraj. And relation, on the right side, the daughter, divorcee. Column 8, my lord.
Daughter divorced.
Yes.
Okay.
And my lord, 11th November 2020, my lord, the arrear pension and the regular pension was released in favor of the petitioner. My lord, the page 20 is the record. The bank statement, my lord, kindly see page 20.
Yes.
Top 11th November 2020, my lord, top, my lord. 3,66,842. And my lord, from that date, she is getting the family pension. But all on a sudden, my lord, the December 2024, 25, suddenly the authorities stopped the family pension without showing any notice, without showing any reason, only stop the family pension. My lord, she applied before the authorities in several occasions, my lord. Kindly see page 25 onward. Before the district inspector of school, my lord, the primary education, and all of the authorities, my lord, but no steps has been taken. My lord, her daughter, my lord, is studying
When
in
did you
the
receive the pension last? When did you receive the pension last?
last month, December 2025, last pension was received.
Was December. What is the amount of pension? 15,000.
Yes.
Was December 2025. This one. Page 21.
Page 21. Well, I have stated in paragraph 10, my lord. The petitioner stated that the petitioner is very much entitled to get the family pension of her deceased father, but the respondent authorities at top the releasing the family pension from the January 2006 to till date without assigning as a lawful reason, and your petitioner is unable to getting the family pension, which is highly illegal, not permissible under the law. But that's after thereafter he made representation before the authorities, my lord. But that has not been considered. Till date, see January to my lord, till date they have not releasing any pension amount, and no order has been passed. With what reason, my lord, they have stopped the pension that has not been communicated to the petitioner till today. Her daughter is studying in the Viswabharati, my lord, university, but not pay, and he is unable to pay his fees, everything, my lord.
Divorced wife is also entitled to. Divorced daughter
Yes, as per memo is entitled. But because my lord, pension payment order has been issued by in favor of her, my lord. So kindly see, my lord. Kindly see page 18, my lord.
You are for the state.
লোকনাথ ছিল লোকনাথ ছিল সার্ভিস করেছে গভর্নমেন্টকে সার্ভিস করেছে তো
It has been served.
হ্যাঁ তাহলে এভিটিভের সার্ভিস মানে handed over. But a very urgent matter, because that's why my several occasions mentioned before your lordship, because my lord, since January she is not getting pension, my lord.
January 26. Then
my lord, I am giving him the copy, one copy, my lord. Kindly
Regularization should be done by your lordship. That regulation is must, your lordship. Your lordship can regularize it, but
affidavit of service filed on behalf of the petitioner is taken on record. By the present petition, the petitioner seeks direction upon the respondent authorities to release family pension in favor of the petitioner in terms of pension payment order dated 29 September 2020 from the month of January 2026. Mr. Swansol, learned advocate for the petitioner, submits that the petitioner submits that she is a divorced daughter of the deceased employee. The petitioner's father was the head teacher of Mathurapur Primary School in Saithia Circle and retired from service on superannuation on 31st January 2017. The father of the petitioner received pension till his demise on 24th January 2018. Mother predeceased. Mother predeceased the father.
Yes, mother.
You have stated. The mother of the petitioner predeceased her father. After the demise of the father, the petitioner, being the divorced daughter, applied for getting family pension, which was granted with a pension payment order dated 29 September 2020. Thereafter, the petitioner received the arrears as well as regular family pension. However, the family pension has been stopped since January 2026 without assigning any reason whatsoever. As such, the petition is constrained to file the present writ petition. Mr. None appears on behalf of the state. Despite service, none appears on behalf of the state. Mr. Brijendra Pratap Singh, learned advocate who usually appears on behalf of the state, is requested to appear in this matter. Let the appointment of Mr. Singh be regularized by the concerned authority. Learned advocate for the petitioner is directed to hand over copy of the writ petition and its annexures upon Mr. Singh, learned advocate for the state. State is directed to furnish a report on the returnable date. Please this matter. Coming week you file a report.
My lord.
কবে হচ্ছে next week টা? Date টা বলুন। 18th August.
18.
Great. In the meantime, you serve the copy so that you can furnish the report on the returnable date.
Client, sir. Because my lord, matter is very urgent, because that's why my lord I mentioned.
What do you want?
Permission, I would like to mention the item number 5. Lordship, the rectification of the name of the Gram Panchayat needs to be changed in a different CPN. You have mentioned 950, that needs to be 2026, CPN 2026. Lordship, in item number 5,
Yes.
you directed them to rectify the name of the Gram Panchayat. So the CPN that you have indicated, that is a different one that needs to be changed.
Not yours one.
No, ours.
No. He will rectify.
No, Lordship, the other side advocate actually reconfirmed that this name needs to be changed. Ours is incorrect.
5টা কোথায়?
NILIMA. We have written LILIMA and they have written NILIMA.
Theirs is correct.
This is correct.
আগে তো নীলিমাই হয়ে। And again, the alleged contemporary comes up and says that no, I am not Nilima, I am Lilima.
Is they never
It
mentioned
is
it.
you who have given the wrong name.
Yeah, it's our mistake on our side.
আমি রেকর্ডটা দেখতে হবে। I will correct the order accordingly. If I find that it is your mistake, then I will grant you leave. If it is his mistake, I will grant him leave. Okay.
Grateful, Lordship. Sure, Lordship.
Record. নিজেও তো অ্যাপিয়ার করলো বল লিলিমা। কি সই করেছিল? লিলিমা। It will be নীলিমা না? লিভটা এঁকে দিন। Leave is granted to learned advocate for the applicant in WPCRC 137 of 2020. You correct the name in your contempt application. Leave granted. রুল তো হয়ে গিয়ে অ্যাপিয়ার করে গেছে। নিজে এসে তো বলছেন লিলিমা, সই করেছে নীলিমা। ওটা করে দিই, আর একটা লাইন বলে দিই যে the name of the alleged contemner in the earlier orders passed by the court be read as Nilima Jana instead of Lilima Jana. All orders, you know. I have corrected the orders as well. In all the orders where there is a mistake, it will be read as Nilima instead of Lilima.
আমি করছি না। Action mark the container is present in filing. And like compliance. Lordship will find surprisingly the order has been complied with, my lord, as back as my lord on 15th of December, my lord, on 30th of June 2025. That is within the period of 2 months as mandated by your lordship. Surprisingly, what has been found, my lord, that the compliance is within the knowledge of the petition. The contempt, the applicant is the contempt application. Well, despite that, my lord, this contempt application has been filed with all humility. I'm submitting, my lord, making some false and frivolous allegations. If your lordship kindly take my lordship, first take the order of your lordship.
That will cause inquiry in respect of respondents.
The order.
Who is block development officer?
Is present.
Is directed to cause inquiry.
Yes,
Yes, caused.
Yes.
Hearing to all parties in the petition.
Yes.
Able to produce SP documents, which will be concluded in the period of 2 months, and they are to require documents are taken appropriate steps in accordance with law.
Now, your lordship, can you take my compliance affidavit? Your lordship will find it page 12. As soon as the order was communicated, the proceedings was initiated on 10th of June 2025. Your lordship will find case number 3 Nauda of 2025. Your lordship will find, for the purpose of my lord holding the inquiry, the technical part at my lord, your lordship, the last line, I'm not, my lord, everyone appears, including the petitioning applicant of this contempt application. Lordship will find Abdul Latif Mandol and Soiful Karikar are directed to be present. My lord, before that, my lord, a committee was formed. Your lordship will find, hearing the submission, it appears that the matter is related to a technical evaluation of submitted papers of e-tender. For scrutiny of these papers, an expert committee of junior engineers comprising of Kajol Kantri Rai, SAE BPC, Rocky Mondal, Junior Engineer, RWP, and Sumit Goswami, Junior Engineer, WRIGD, attached to this block under the supervision of the Block Development Officer Noda, will check the submitted documents of the petitioner in presence of the Pradhan and on Nirman Shayab of Rajpur Gram Panchayat and the petitioner, namely Abdul Latif Mondal and Sariful Karikar, on 23/6/2025 at 1:30 p.m. So, Your Lordship, the committee was formed for the purpose of, my lord, the evaluation of technical. Your Lordship, on 23 out of June 2025, my lord, somehow copied it.
May take a copy, my lord.
Sorry. Page 13, if Your Lordship kindly come to, that on 23rd of June 2025, somehow the hearing could not be held. Now, if Your Lordship turn to page 14, Your Lordship will find that in compliance to the order, my lord, everybody appeared, everybody was heard, every document was scrutinized by the committee and by me, my lord, by taking assistance from the committee. Thereafter, Your Lordship will find in page 16 that technical bit, everything was recorded. And now, Your Lordship, kindly come to page 17, the operative portion. On an overall appreciation of the fact as canvassed on the argument of both parties, and the petitioning applicant appeared with a learned advocate. And that was permitted also. And all relevant documents are advanced by both the parties. The following points have been found by has been formed, which are as follows. In the NIET, the question of being neat number such and such, there were total 4 numbers of words. The objection was raised against the serial number 3 and 4. Ortho o Prokolpo Uposhamiti Committee of Raipur Gram Panchayat rejected the paper of the Abdul Latif Mondal due to non-submission of professional tax certificate for the year 2024-2025, but it is found from the submitted uploaded document that he has submitted P-tax certificate for the year 2024-2025, which was overlooked. In case of Sariful Karnikar, there was discrepancy in schedule name in the payment certificate, completion certificate, and schedule. But the Panchayat could have easily checked the authenticity of those certificates, though written communication to the concerned authority, through written communication to the concerned authority. It is found from the resolution dated 17/1/2025. The executive assistants of Nirman Shayab and Raipur Gram Panchayat were present in the meeting of Ortho Porikalpana Uposhamiti held on 17 January 2025. It is clear that Ortho or Porikalpana Uposhamiti of Raipur Gram Panchayat has not performed its activities as per the rules and regulation of the West Bengal Financial Rule and West Bengal Gram Panchayat Procedure Manual 2024, and rejection of bidder was not done properly. Having considered the submission of both the parties and material placed on record, it is found that the Pradhan of Raipur Gram Panchayat has violated the all existing acts and rules in connection with the tender process. That the Pradhan is directed to take appropriate steps to reconsider the decision taken on 17/1/2025 and evaluate financial bidding of NIIT number such and such afresh as per the West Bengal Financial Rule and Panchayat Procedure Manual within 2 weeks from the date of communication of this order. It was, my lord, remanded back to the Pradhan because, Your Lordship, Section 32A, my lord, the Pradhan, my lord,
32A
of the West Bengal Panchayat Act, the Pradhan, my lord, Your Lordship, kindly take that.
My lord, but now, my lord, start the copy, my lord. I will file a reply, my lord.
Well,
Kindly fix the
on
date.
record, my lord,
Jahan
I can
is
show, my
appearing
lord, the
this
contempt
matter.
application is not at all, my lord, should, my lord, remain pending, my lord, for a minute.
I will reply, my lord. I will reply.
That's a kind 32A.
Kindly allow me, my lord. I will reply, my lord, within a week, my lord.
Sir, wait, please.
32A, Lord, kindly see that the Ortho or Porikalpana Uposhamiti, my lord, Your Lordship, now take subsection 3. The Uposhamiti referred in
So
subsection 2.
this is rule you're reading. You're reading from
No, Act 1972, 32A section.
This is Constitution of Uposamitis.
Yes,
Okay.
Constitution of
Yes, yes.
The Uposhamiti, as specified, Your Lordship will find in subsection 2, Roman 1, Ortho or
Yes,
Porikalpana Uposhamiti.
Yes.
It is headed by the Pradhan and the Upradhan as the ex officio member. So, Lordship, the matter was remanded back to the ex officio member, and my lord, because since the Pradhan is the head of the Uposhamiti. Now, if Your Lordship takes the contempt application for a moment, Your Lordship will find in page 40, this order has been, my lord, annexed with the application, and my lord, no averment has been made as to this order. And my lord, what allegation has been made? Kindly see, your lordship. This order has been passed. It was communicated. They have annexed, but not a single pleading will be, my lord, your lordship will find from the application for contempt. And what allegation has been given, your lordship, kindly see in page 20 to page 19, the prayer. Rule NISI may be issued upon the respondent number 8 and 9 being alleged contempt number 1 and 2 with a direction by showing cause as to why they should not be guilty under the Contempt of Courts Act 1971 by this honorable court and adequately be punished for committing willful and deliberate violation of the said certain order passed by this honorable court dated such and such, passed by my lord Justice Vikas Patnaik in WPA number such and such. Now you will also kindly see the specific contempt or they have alleged by not cause any inquiry in respect of the representation dated 26 January 2025 of the petitioner before hearing the parties, including the petitioners, without considering the documents as produced by the petitioners within the period of 2 months from the date of communication of the said sermon order by the respondent number 8, therein being the block development officer and the development block Murshidabad. That is the allegation. Within 2 months, the inquiry was held, all the documents was perused, the order was passed, they accepted the order, they annexed it. Now you will see the allegation. It's completely contrary to record. I should, my lord, submit people with all humility. This contempt application should be dismissed with some exemplary cause. It is nothing but an harassing application.
I will reply. Kindly fix the date. I will reply.
No, what he has submitted, what is your grievance to that?
Mr. Jahan is appearing in this matter. This is engaged in court number.
Where is he?
12.
Ask him to come.
That is engaged in appeal, court number 12. Kindly fix the date.
It has been complied with. Why did you find the contempt application?
I will reply.
And my lord, when the order was passed and when the contempt application was filed, when the contempt application was filed,
I will reply. Kindly
25. When
the order was complied, day after tomorrow,
30th of June,
day after tomorrow, I will reply.
After 6 months of the compliance with their knowledge, and my lord, this document, my lord, this order has not been, my lord, pleaded
And the
in
case be kept pending since it is not suiting your purpose.
You should kindly let them show from their statement that this order has been averred. Any averment has been made regarding this order.
Why did you say that the inquiry has not been held? Documents were not allowed to be produced.
The inquiry was held, but
when it has been recorded in the order that these documents were placed,
held,
inquiry was held.
The inquiry was held, but no step has been taken till date.
Unnecessarily.
Order was complied.
But kindly,
They have
day
accepted the
after
order.
tomorrow,
They are
kindly,
dedicated
day after tomorrow, I will
second
reply
the
all
order.
these things, my lord.
There's no rule ought to be. Only one against one has been issued.
Yes, yes.
Alleged contemner number 1, Mr. Devashish Sarkar, Block Development Officer, Northern Development Block, is present. Affidavit of compliance filed by the alleged contemner number 1 is taken on record. Copy served. Mr. When sole honored advocate representing the alleged contemner number 1 submits that pursuant to order of this court, the alleged contemner number 1 has taken all necessary steps for causing inquiry, and a reasoned order has been passed directing for press directing for reconsideration of the decision taken by this is evaluating committee. Which committee has taken the decision? Taken on 17 January 2025.
Committee
অর্থ ও পরিকল্পনা উপসমিতি of Raipur Gram Panchayat, and the matter was disposed of. The applicant petitioner had the knowledge of such order. However, without any plausible reason, the contempt application has been filed, though the alleged contemner complied the order of this court by passing a reasoned order upon causing inquiry. Mr. Swensol, learned advocate, seeks accommodation Next week, the appearance of the alleged container number 1 is dispensed with for the time being. Next week, this will appear. Let them go through that.
At 2 p.m., my lord. 2 p.m.
It has been dispensed.
Dispensed. Eighteenth.
Like any day apart from 18th. 18th I have something.
Thursday te diye din. Time diye din. Thursday te first ही कर लो. 20th. 20th first hour I will take it.
Where to?
Lord, I beg.
My lord, I am for the petition.
I beg to appear for the alleged container, my lord. This is the affidavit of compliance.
Well, affidavit of compliance. Where is that?
My lord, will find at page 16. The matter has been referred to the subdivisional officer. After
It has been complied with.
No copy.
I'm serving, my lord, right now.
Where is the forwarding letter?
My lord. My lord will find the recent order at page 19, my lord. 67 square feet has been found unauthorized, my lord. And at page 16, my lord, it has been referred to the concerned subdivisional officer. Page 14 is the map annexed, my lord. At page 25, my lord, it has been communicated to the parties.
The appeal has been disposed of. There is an appeal filed.
Matt is pending, man.
What is the status of that?
Matter is pending, my lord. No update.
I believe.
None. Stay, there was a stay, my lord. No stay till date, my lord. No matter is not mentioning till today.
No stay granted.
Stay also filed, my lord. No,
Not moved.
Not
Not
moved,
moved.
my lord, I believe.
The matter has been referred to the SDO.
Yes, my lord. At page, my lord, 16. Annexing the recent order.
Affidavit of compliance filed on behalf of the alleged container, filed by the alleged container. We have taken on record. Learned advocate representing the alleged contemner submits that upon inquiry, it was found that there is unauthorized construction of 67 square feet, which requires to be demolished. The matter has been referred to the subdivisional officer, page 16.
11th, my lord. Recent order was passed on 7th and referred on 11th, my lord.
16, ঠিক আছে. And the matter has already been referred to the subdivisional officer Sirampur, Hooghly on 11th August 2026. আজকে ওখানে যেটা অ্যাফিডেভিট অফ কমপ্লায়েন্স ফাইল করেছে ওখানে বলে কপি সার্ভড টাইম সেটা কি ডিসপেন্স করে দেবে ডিসপোজ করে দিচ্ছে আজকে since it is found learned advocate for the petitioner. Yes. What is your submission?
My lord,
it can be disposed of?
My lord.
Concedes to the same. In view of the above, WPCRC number 82 of 2026 stands disposed of. The rule stands discharged. Appearance of the alleged contemner is dispensed with. No personal appearance of the alleged dispensed with.
Obliged.
Great. আপনার পাস করেছে নাকি ছয়
I'm appearing on behalf of the Irish contact members.
Before
my affidavit in compliance, madam.
You have complied?
Into the bit.
Uma Maji.
Compliance has completed and my lord, construction is unauthorized and illegal.
It has been forwarded to the SDO?
Yes, my lord.
Where is the forwarding letter?
My lord, at page number 18, my lord.
Yes. Strategy? And dispose it of?
Yes, Palani. But kindly give it, I'm praying for one intelligence, kindly give a direction to the SDO. Otherwise, the SDO will do nothing, man.
Affidavit of compliance filed by the alleged contemner is taken on record. Para, Mr. Swenso, learned advocate appearing for the alleged contemner submits that the order of this court has been complied with. Upon inquiry, it is found that there is unauthorized and illegal construction. The matter has been referred to the SDO under section 23(5) of the Panchayat, West Bengal Panchayat Act 1973 for further course of action. Mr. Jyoti Prakash Chatterjee, learned advocate for petitioner applicant, concedes to the same. View of the above, WPCRC 164 of 2026 stands disposed of. The rule discharge, personal appearance of the alleged contemner is dispensed with. Next.
আমার নামটা দিয়ে দিচ্ছি
I am for the petitioner, my lord. On last occasion, your lordship directed my learned friend submit report.
My lord, I am submitting.
But the case of petitioner is that, my lord, the petitioner is a widower. My lord, his wife was the school teacher, primary school teacher, my lord, retired on superannuation.
Husband exercised option.
Lord, 1990, he has been opted for revised pay.
Why have you written 1998?
98, Lord, also, Lord, PPO said so, 1998 also. PPO said so, Lord.
When did the husband die?
Died, Lord, no, not Lord, wife. Wife died, Lord, on 27th of November 2015.
Wife died. TCRBC.
No, 1998 and 1990 I had opted.
Come under this.
Lord, I have stated in paragraph, Lord, 6 I have stated, Lord. And 7. In similar situation, your lordship, the past Lord order is there. I have also annexed the same. Page 33. My representation is, my lord, page 22.
Yes.
My lord, just we have filed our instruction, your lordship, that para number 4, as per notification such and such on dated 13th June 2014, the employee did not exercise option to come under DCRB 81 scheme, your lordship, so the petitioner is not entitled to get family pension. That is my humble submission, your lordship, and that is duly been admitted by in their pleading also, your lordship. That is page number 6, para number 12. That your petitioner states that his wife died on 27th November 2015, but the circular is issued on 13th June 2014 for submitting the option for CPF to GPF within 3 months, as per the petitioner's wife was bedridden and had been living in the rural areas. She did not know regarding the said circular, your lordship.
Okay. Ashwin. By the present writ petition, the petitioner seeks direction upon the respondent authorities to permit the petitioner to deposit the government's share in the contributory provident fund with interest and additional interest in order to avail the benefit of family pension. The petitioner contains that his wife, namely Nanda Rani Maiti, was an assistant teacher in Yogoda Satsango Palpada Junior Basic School, Post and PS Palpada District, Purbo Medinipur. The petitioner's wife retired from service on 31st January 2006. Retired from service on superannuation. The wife of the petitioner died on 27th November 2015. The petitioner is the widower of the deceased employee. Top. During her service tenure, the wife of the petitioner opted for revised scale of pay in terms of Rupa 1990 and Rupa 1998. Pension payment order.
My lord, if my lord, annexed my lord, my lord, my lord, page 20, 20 and 21, my lord.
Pension payment order was issued in favor of the wife of the petitioner on 6th September 2006.
And my lord,
with gratuity only, na? With gratuity only. And without pension.
and another PPM lord, 5th of January 2012. Page 21, my lord.
And revised pension payment order was issued on 5th January 2012. No pension was granted. Without none, no pension was granted. আগের লাইনটা Did the petitioner made any representation before the authority?
My lord, page, my lord, page 22, my lord.
On 5th March 2026, petitioner made a representation before the concerned authority for grant of family pension upon refund of employer's share. Did you mention that you will refund that amount?
My lord, I have mentioned, lord.
Upon refund of the employer's share of contributed provident fund together with interest and additional interest. However, no steps have been taken till date. Hence this writ petition. Same subdivision. এইটুকুটা বাদ দিয়ে দেন এখান থেকে এটা বাদ দিয়ে বলেই দেব নোট করুন Uttam Kumar Bhattacharya, learned advocate, appearing for the petitioner, submits that the wife of the petitioner during her lifetime exercised her option under ROPA 1990 and ROPA 1998. In the event such option is exercised, the petitioner being the widower of the deceased employee is not required to exercise fresh option, comma, however, in order to get benefit of pension, he is obliged to refund the government share of contribution in his wife's provident fund. The petitioner is willing to refund the amount to be calculated by the district inspector of schools respondent number
My lord, respondent number
4.
Lord,
E-
4.
Purvo Medinipur. In support of his contention, he relies on the decision of Honorable Division Bench of this court in state অমুক ঠিক আছে এটা এই অবধি থাকবে
Page 27.
He seeks that specific direction be issued permitting the petitioner to deposit the employer's share in contributory provident fund together with interest and additional interest in order to avail the benefit of family pension. Para. On the contrary, report filed by the state is taken on record. On the contrary, Mr. Brijendra Pratap Singh, learned advocate appearing for the state respondents, submits that the employee did not exercise option to come under DCRB 81 scheme. And as such, the petitioner is not entitled to get family pension. He seeks for dismissal of the writ petition. Having heard the learned advocates for respective parties, the only issue which falls for consideration is whether the petitioner, being the widower of the deceased employee, is entitled to family pension in the given facts and circumstances. Next paragraph. Undeniably, it is undeniable that the wife of the petitioner opted for revised scale of pay under ROPA 1990 and 1998. Para. At this juncture, it would be profitable to reproduce relevant paragraphs of the decision of Honorable Division Bench in Sefali Jana Supra in similar circumstances as follows. Relevant observation koro. Paragraph number relevant observation. এটা কোড করবে এখানে 12 থেকে। Bearing in mind the aforesaid observation of the Honorable Division Bench, there is no requirement of giving fresh options for switching over from contributory provident fund to pension cum gratuity scheme, since petitioner's wife already opted for revised scale under ROPA 1990 and ROPA 1998. In the aforesaid backdrop, respondent number 4, District Inspector of Schools, P. Purbo Mednipur, is directed to calculate the amount required to be refunded by the petitioner in order to get the benefit of pension, and upon deposit of the said amount, the respondent, being the pension sanctioning authority, shall verify the pension papers of the petitioner and forward the same to respondent. DPPG is respond number?
3.
Director of Pension, Provident Fund and Group Insurance, Government of West Bengal, for further steps to be taken for issuance of pension in favor of family pensioner in favor of the petitioner within a period of 8 weeks from date of communication of this order. Next paragraph. The family pension shall be paid to the petitioner on and from the date following the date of. It will be which date? Death.
My lord, death.
Date of death.
Death, my lord. 27 November
Following
2015.
the date of death of the deceased employee.
Retirement, my lord. Retirement, my lord. Superannuation.
Huh? It will be from which date?
Lord, that is, my lord, 31st of January 2006. Date of superannuation.
In that judgment, it is date of superannuation.
My lord, superannuation.
From the date following the date of superannuation of petitioner's wife.
31st of January.
This order. What a date of death to get in?
31st of January 2006.
2006.
31
Disposed of.
Grateful to Allah. 31/2006. 31/2006. Grateful.
Before.
Well, I'm appearing for item number 727 and 729.
I am for the writ
My lord, in
petitioner.
all these matters, there was a direction to file an affidavit in opposition to the supplementary affidavit. My lord, uh, after that, my lord, I sought for a conference and I made a questionnaire because the recruitment process, it was started in 13, examination held in 21. So I had a very specific questions because I was not very satisfied. Now they have the commissions, they have not been able to gather all the things. I'm only seeking, my lord, some time to use the oppositions. My lord, my
Well, this is the third time well, they are extending the time.
not third time. The last order was on 23rd of
No,
July.
no, this is the third occasion.
No, what I'm saying is supplementary affidavit in 7268 that was given on 23rd of July.
No, our supplementary affidavit was filed on
I
7th
want
of
to go into controversy.
8th of July.
I should have been, but my lord, without those
Pratik
things.
Thor, learned senior advocate, appearing for West Bengal Madrasa Service Commissions, seeks further extension of time to file supplementary affidavit in opposition. The others you have filed?
No, no opposition has been
The
filed.
stand we take, my lord, it has to be the one stand.
Okay. Supplementary affidavit in
In all the
opposition
matters.
to the supplementary affidavit filed in WPA 6274 of 2022. In all the matters, supplementary affidavit has not been filed.
No, ultimately,
No,
what we seeing the order dated 23rd of July.
Yes.
My lord, I have
Prior to that, there was a recording that supplementary affidavit in one matter is not filed, but ultimately, this was filed also.
Supplementary affidavit in the
5916, my lord, 7268 I have filed.
7268 6274 has been filed.
5916 also filed, my lord.
5916.
Yes.
So the other 572, sorry.
Murshida, there is no supplementary.
Supplement. So in 3.
Yes.
623.
Resman Assis
Further
Pera has been
extension of
filed.
time to file supplementary affidavit in the writ petitions accepting WPA 7965 of 2022. Let such supplementary affidavit, you tell me?
My lord,
within which period
my
is
instructions was because they are findings because they said 3 weeks. Now I leave it to your lordships, my lord.
make it within 2 weeks?
2 weeks, my lord. Kindly,
But that's reasonable.
my lord, 2013.
I understand.
Advance copy may be served upon us.
Advance copy of such supplementary affidavit in opposition be served upon the learned advocates for the petitioners in the writ petitions. 2 সপ্তাহ পরে
Kindly fix the, otherwise, my lord,
I'm also, my lord.
kindly fix the matter, my lord.
7 September.
Grateful, my lord.
Obliged.
My lord, can a time be, my lord?
My lord, same time, my lord.
Oh.
September.
27th August. তাহলে অগস্ট এন্ডে দিয়ে দাও বলে দিন ডেটটা বলুন
27th.
ঠিক আছে 27th August.
Grateful. For same time.
The other
Same time.
Yes.
3 p.m. পর্যন্ত
my lord, the other matters parties to my lord. My lord, the next
No, which matter?
The next hearing matters, the branch matters, my lord, same respondents, my lord. Mother service composition matter. Next.
No, we will go back to the list that was being called. Motion 1.
My lord, can it time be fixed for the next one?
No. Yes. Which item?
Item 18, my lord.
18.
I'm grateful.
But, on the last occasion, my lord was pleased to direct the state to file their report, my lord. The petitioner retired from service on attaining the age of superannuation with effect on 31st March 2026, my lord.
Yes.
My lord,
What is the report? State. Where is your report?
Up till now, no report has been.
Why? He's not getting the pension without, he says that without any reason this has been withheld. If any document is wanting, you inform them so that they can place and
Number 60 in problem is lying with the JDA, Joint Director of Accounts. But this authority has did some.
Joint Director of Accounts.
No, what is the report? Why this has not been disbursed? This has been copy forwarded to
But
JDA objection here. JDA objection. Where is that JDA objection? This letter says that there is an objection raised by Joint Director of Accounts. Where is that objection, Mr. Bose?
But that objection is not with me, my lord. I have submitted the revised, my lord, the pension papers, my lord, page 61.
Yes.
Page 61. That is the revised, my lord, the pension application, my lord. My lord, the for removal of the objection, my lord. But till date, my lord, the pension has not, no, my lord, terminal benefit has been, my lord, disbursed, my lord. But I am at least entitled to get the provisional pension and as well as the provident fund, my lord. But without prejudice to my rights and contention, my lord.
If you are entitled to full pension, why provisional? You have been suspended?
No. Never.
The case is there?
No, my lord, never. But we are suffering since, my lord, 1st April, my lord. I have attained the age
no
of...
instruction. Sir, you have no instruction.
I have no instruction. Up till now, I'm again communicating.
Who is the authority who will file the report?
At the
DI.
District Inspector of Schools, my lord. At the
DI primary.
But the pension sanctioning authority is the
DPPG.
DPPG, but that will be forwarded by the DI.
Yes, my lord.
Come up with a report in the next day on 18th. এটাকে ওপর দিকে রাখবে যেন থাকছে 6 further extension of time to file report. Please this matter on 18th. Let such report be filed on the returnable date. Come up with a report or the DI has to be called. If you have any objection, you indicate what is
Yes,
the
ma'am.
objection.
We shall
that can
comply.
meet out the
We shall
objection.
comply. Oh, if any objection is there, ma'am, we shall comply.
Get first.
Get.
Yes. My lord, I am for the petitioner. The matter relates to family pension. Petitioner is a disabled son of a primary teacher. His father died in 1975. That is before the introduction
Daughter.
of my lord.
Daughter.
Son.
Son.
1975. That is before introduction of DCRB scheme 81.
Four.
2009, the disabled children were defined wherever retired from service after 1900 prior to in also be eligible for grant of family pension. Yes. Will not be entitled. Why?
Because of that, January 2009, difference that there are
Which rule? No, which rules enable the disabled children to have employment? Which is the rule? I am asking you, what is the rule by which a disabled child of the deceased employee gets that? What is the rule?
Or this is the rule.
Is it say that there is a bar? This is the memorandum.
This is the memorandum, and here in column 2.
13 January, column 2, not changing continuing. 18, In 2005, government please
Memo-
this has been
memo টা
changed
নেই?
as given para after but prior to considering
And the issue has already been settled pursuant to decision of the Honorable Special Bench in Sobita Rai's case. And
Where is that?
in terms of the said order, Your Lordship, my Lord also passed
They are referring
several
to para
orders.
2. Para 2 say that after 81, the father has retired in
Before
1975.
My Lord also passed several orders in terms of order of this Honorable Special Bench. Paragraph 6.
What does paragraph 6 says?
Paragraph 6 says, my Lord, the Honorable Special Bench, or paragraph 6 of my Lord's order.
T case. The law is now well settled. Indians will retire prior to.
That who retired prior to 81, in that case also the family pensions.
Ability. Does the petition being handicapped sons? You have the memorandum of 5th September. 5th September.
5th September. I'll let you know. My Lord, the memorandum of 5th September has been quoted in the order of 2009.
Para? 5th September 2005 notification.
My Lord, that has been quoted in the order. My Lord, order of 2009. The memorandum of 2009. I have handed over to Your Lordship first. Initially, it was applicable up to the age of 25 years, pursuant to memorandum of 5th September, and thereafter pursuant to memorandum of 13th January 2009, that has been extended till life. But pursuant to decision of the Honorable Special Bench, my Lord, that issue has been settled already. And number 2, my lord, in memoranda of 2009 in para 3,
ये দেবনাথ বাবু বলুন তো এই ডিসিশনটা বার করতে একটু WPA 22029 of 2023. আসুন by the report filed by District Inspector of Schools, Primary Education, Paschim Mednipur, dated 28 July 2026 is taken on record. By the present writ petition, the petitioner seeks for grant of family pension in his favor with effect from 26th April 2019. Where is the order?
page 27.
27.
Initially,
And for-
pursuant to direction
and
of this
for-
honorable court,
Upon cancellations and or quashing of the impugned memo number K/RM/P/00122/2026 dated 12th May 2026 issued by dated 12th May बोला ना issued by Assistant Director Directorate of issue response number 3, Assistant Director, Directorate, Pension, Provident Fund and Group Insurance, Government of West Bengal. The petitioner contains that he is a handicapped son of
Paragraph 3.
what is the name of the father? Late
Well, paragraph 3 I have stated. Late
Rajendranath
Rajendranath
Dhara,
Dhara.
who was an approved head teacher of Brahmanipur Primary School under Pingla East Circle District, Paschim Medinipur. The petitioner's father retired from service on superannuation on 30th June 1975 and died on 28th May 1985. The petitioner's father did not receive any monthly family pension. Stop. Upon demise of the father of the petitioner, his mother applied for family pension, which was allowed vide PPO dated 5th April 2012. When did the mother die?
Mother died on, my lord, 25th April 2019.
The mother of the petitioner, namely Biraja Dhara, died on 25th April 2019. After the demise of the mother, the petitioner applied on which date? Applied on which date?
My lord, apply date of application. my lord.
Petitioner is 25.
Page 25 is the second application, but initial application. No, first application has not been annexed, your lords. June 2025, page 22, your lordship. It has been mentioned in earlier order.
30th?
30th June 2025.
On 30th June 2025, petitioner made a representation for grant of family pension. However, since the same was not considered, the petitioner preferred a writ petition being WPA 20486 of 2025, which was disposed of by this court on 7th November 2025 with the following direction. Para 6. Pursuant to such order, the petitioner's case was considered by the respondent authorities. However, the family pension has not yet been granted. Hence, this writ petition. Mr. Kullan Kumar Panda, learned advocate, appearing for the petitioner, submits that referring to decision of larger bench passed in the state of West Bengal and others versus Sobita Rai, remat 1518 of 2019, submits that the law is now well settled that a teaching and non-teaching staff who retired prior to 1st April 1981 or after 1st April 1981 was entitled to get pensional benefits in terms of DCRB scheme 1981. Stop. The unmarried or widowed or divorced daughter of an employee is who retired prior to 1st April 1981 or after 1st April 1981 is entitled to get family pension on fulfillment of the requirements of Memorandum number 96 AC dated 13th April 2010. By Memorandum dated 5th September 2005, the family pension is also extended in favor of son or daughter suffering from disorder or disability of mind or who is physically crippled or disabled. Thus the petitioner, being a handicapped son of the deceased employee, is entitled to receive family pension. He seeks for setting aside of the observation made by respondent number 3 in its letter dated 12th May 2026, Annexure P10, and grant family and direct the respondent authorities for grant of family pension in favor of the petitioner. On the contrary, learned advocate representing the state respondent submits that the father of the petitioner retired much before 1981. Para 2 of the government order number 10-AC within bracket B/0/1M-131/2008 Part 1 dated 13th January 2009 clearly provides that the disabled children of those employees as defined in the paragraph above who retired after 1st April 1981 but prior to 5th September 2005 will also be eligible for grant of lifetime payment of family pension. The father of the petitioner, since has died prior to 1981, the petitioner is not entitled to receive family pension. Upon considering the submissions advanced on behalf of the respective parties, the only issue which falls for consideration is whether the petitioner, being a disabled son of the deceased employee, is entitled to family pension or not. In Sobita Roy Supra, the full bench of this court observed, larger bench of this court observed as follows. Para 6 again, Neven. Upon going through the aforesaid proposition, it is now settled that widowed, unmarried, divorced daughter of a deceased teacher retired prior to 1st April 1981 was found entitled to family pension. By memo dated, memo number 325 AC B/1M 7th page dated 5th September 2005, the family pension was extended in favor of son or daughter suffering from disorder or disability of mind or who is physically crippled or disabled. In similar circumstances, a coordinate bench of this court in Anupam Chakraborty versus State of West Bengal and others observed directed for issuance of family pension in favor of physically handicapped son, observing as follows 5 and 6. In the aforesaid backdrop, the observation made by respond number 3, Assistant Director Pension, Provident Fund and Group Pension Government of West Bengal dated 12 May 2026 is hereby set aside in the light of decisions as above. Respondent number, District Inspector. Respond number. District Inspector of Schools, PE. This is Paschim Mednipur. Paschim Mednipur is directed to verify the disability certificate of the petitioner from the issuing authority forthwith and forward a report to the respondent number director.
Respondent number 2.
2. Director of Pension, Provident Fund and Group Insurance of West Bengal within a period of 1 month from date of communication of this order. Upon receipt of such report, para, and if found to be genuine, respond number 3, Director of Pension, Provident Fund and Group Insurance, Government of West Bengal shall issue a pension payment order in favor of the petitioner within a period of 1 month from date of receipt of the report from the District Inspector of Schools, PE, Paschim Mednipur. The Director of Pension Provident Fund, with respond number 3.
2, my lord.
2. 2 হবে is further directed to release arrear of family pension, if any, in favor of the petitioner. Disposed of.
With effect from my lord 26th April 2019. Area.
If any, in favor of the petitioner. No. Mr. Das, you appeared in a matter in which this second wife, Mr. Kamal Misro, was there. Mr. Bishwaru Biswas was also there. It was argued that the second wife, Hindu second wife of the deceased employee is entitled to family pension.
But if your lordship kindly, if applied the 2009 DCRB, he will not entitled.
That was not argued. I have checked it. 2009 rules was not argued.
My lord, what happened was initially Mr. Mishra does not give any griefs. So he wants the why is the page of 1981 provided. No copy has, if it has been given, I should have indicated.
Will you ask Mr. Biswas to come tomorrow? Otherwise, I will place the matter under to be mentioned for clarification. If required, because that will be a wrong interpretation of law.
Definitely, if it is, I have also checked up the rules, and I found that note which is given in the earlier 1981 has been not been amended.
Yes, in 29, if it is 29 and 43, if you read, any rule that is repugnant in 81 will not be applicable in 2000.
I inform.
You correct that audit. Need correction.
For that rules, I have understood that there is a mistake.
Ask Mr. Biswas, you also remain present tomorrow. We'll fix a date and clarify that. এটা ওর মধ্যে রেখে দিন তো।
My lord, item number 746, I appear for the petitioners.
I'm for the Madrasa board led by Mr. Nadim Suleiman.
Your argument is complete.
Yes. I have completed petitioners from side also completed. Only state.
You have made your submissions on
Yes, my lord.
huh?
Yes.
746. You have filed a report.
His affidavit opposition is
Okay.
on behalf of the district inspector of schools.
Okay.
At what situation condition the honorably compelled to appoint video and recommended for appointment of administrator. So page 16 of the
Affidavit in opposition for Madrasa education.
page 16 that prayer A and we see the prayer.
Yes.
Now, order direction or reconsideration of amendment or any other appropriate order direction, we go receive before include proposal for appointment of administrator, the manager in 12 petition, and also the include office order, if it's one, so we can say order issue. So the first is the proposal, challenges proposal for appointment of administrator, and second is the appointment of order has been issued for appointment of DP. So what prompted? Whether can we come to affidavit in opposition? That here is affidavit in opposition, categorically stated.
This is response number 11.
8, my lord. 8.
8. In opposition by response number 8.
Eight, yes.
Page 2. Paragraph 4. Yes.
Yes, paragraph 4.
That before dealing with the respective paragraphs of the repetition, I read the brief that as follows. The Director of Madrasa Education Additional Secretary Government of West Bengal, to its memo number so dated 22nd May 2025, asked the district inspectors to Malda to submit pro forma report A within 7 days in respect of the petition, civil number so and connected 38 matters. Accordingly, the teacher in charge of the petitioner's madrasa, named Vatana JMO Senior Madrasa, along with other 7 madrasa, were requested through office memo number so dated 23rd May 2025 to be personally present in the office of the district inspector of schools, Malda, on dated 26 May 2025 at 8:11, along with the file request pro forma report A and other important documents. 2. Only the teacher in charge response number 10 of the petitioner's madrasa does not comply with the direction dated 23rd May 2025 of the district inspector Malda. The TRC of the concerned madrasa was issued show cause letter, memo number so dated 27th May 2025 for non-compliance with the direction dated 23rd May 2025. Mr. Ghulam Rasul, the assistant teacher at the TIC of the madrasa, on dated 29th May 2025, replied that secretary and MC, I am emphasizing this part. On Muhammad Ghulam Rasul, the assistant teacher at the TIC of the madrasa, on Ato replied that secretary and MC members of the concerned madrasa on a dated 75 are asking to agree with them on some issues related to some unfair appointments but he did not agree to that. He fell ill when they put so much pressure on him. Being unable to bear this pressure, he became mentally disturbed and tendered his resignation from the post of PIC on dated 27 May 2025. It is to be noted here that the Principal Secretary Manually Affairs, Madrasa Education Department, Government of West Bengal, the District of President, Malda President West Bengal Board of Madrasa, the District Inspector Malda, some other officials made surprise visit to the concerned Madrasa on dated 10 June 2025. All were visited and inquired about the issue. The concerned PIC submitted written declaration in front of the said officials that he was forced by the secretary and other members of the concerned madrasa to tender his resignation. This is the position. A team consisting of the secretary, principal secretary, district magistrate, visited the madrasa.
But then why? No, what was the reason that such an circumstances has arisen? What is the reason for visiting DI and the district magistrate?
The application was filed before the Honorable Supreme Court for regulation of the teachers.
Is it Snehasis Giri? 566 is the Snehasis Giri?
Yeah.
That my lord.
Civil appeals 566.
That judgment was handed up to your lordship on the last occasion.
No, is it Snehasis Giri?
Is it cost title Snehasis Giri? I don't really remember the cost title, my lord.
Yes.
Najma Khatun something.
Najma Khatun was there, my lord. Last occasion we have handed over.
Najma Khatun?
Yes, my lord.
Finally sees, my lord. I don't remember, my lord. Subject to correction, my lord.
Najma Khatun.
Najma Khatun.
The district inspector Malda Police memo dated so dated 30th May 2000 requested the President West Bengal Board of Madrasa to take action for non-compliance and non-cooperative attitude from the end of the authority of Patna JMO 6 SXR Madrasa Malda. The West Bengal Board of Madrasa Education number this was recorded again. On 17 June 2025 at 1 p.m. at the conference hall of Maulana Abul Kalam Azad Bhavan, Calcutta, regarding the affairs of Patna JMO Senior Madrasa Malda. The secretary of the concerned madrasa attended the hearing due to some unavoidable and district inspectors in Malda could not attend the hearing on 17 June, but submitted report regarding the affairs of the concerned madrasa through its memo dated Swansea. The West Bengal Board of Madrasa through its memo dated Swansea directed the district inspectors to Malda to place the drawing and disbursement officer in Patna JMO Madrasa Malda, and also directed to send proposal for placement of administrator in the same madrasa. The district inspector school Malda to his memo number dated 20 June 2000 placed the Janab Masood Karim Ansari, sub-inspector school attached to the office as DISSC Malda's DDO of the concerned madrasa. This was the background which prompted the authority to appoint the joint disbursement officer. They were given ample opportunity, scope to comply the direction of the DIS and also the Madrasa Board and also Secretary of Humanity Affairs. They did not comply. On the contrary, it is evident, my lord, that they have adopted illegal practice of protecting the allegation of illegal appointment of the school teachers who went up to the school. That was the reason. But that is different issue. Here is the disobedience of the superior authority's order and disobedience of the direction of the Madrasa Board as also district inspector of the school. That was taken into consideration. Not
But
only
your case is that they took the documents to the office of the DI, but that was not accepted since the DI says that the TIC is not the secretary or TIC, who is not the authority to carry.
Secretary is not the
Secretary
custodian
is
of
not the
record.
authority to carry such valuable documents. But the documents were kept by the DI. They say that we have complied your letter.
Nothing is there. That is their statement. That is their statement. Without supporting any evidence. Without supporting any evidence. So now they come to the, my lord, the order.
Page number?
Page 7. Oh, I'm sorry.
That is the order under challenge. As the proposal.
47.
47A. As the proposal, 47A, the proposal. Thereafter, appointment of the and drafting letter of first I am placing the 47A. Whereas the managing committee at a writ petition, 47A, 47A. Whereas the managing committee of Patna JMO Senior Madrasa PO Patna District Malda in numbers 1 to have been reconstituted with the approval of the West Bengal Board of Madrasa Education by numbers 1. And whereas the board receives some information regarding affairs of the Patna JMO Senior Madrasa, that it is the task of the management of recognized non-government madrasa rule 2002. And whereas to verify such information, the West Bengal Board of Madrasa Education issued a hearing notice by numbers 1 to the district inspector, Madrasa Secretary, Managing Committee, Madrasa Senior, Madrasa Teacher Instead, Madrasa Senior Madrasa. The hearing was scheduled to be held on 17 June 2025. In the meantime, the board made a surprise visit to the Patna JMO Senior Madrasa in 2025. So board also made visit. This is not on the basis of the GIS report. Board also visit. The second principal secretary of the minority cell also visited that. And whereas the district inspector is to submit a report by number to so and so, where he has recorded his observation regarding the mismanagement by the managing committee, Patna JMO Senior Madrasa. Whereas during the hearing of the secretary of the managing committee could not keep whereas during the hearing of the secretary of the managing committee could not give a satisfactory reply regarding the mismanagement of the managing committee, Patna JMO Senior Madrasa. The teacher in charge was also absent in the hearing despite receiving the hearing notice. Now, therefore, for the interest of the madrasa and its students, the undersigned is directed to request to create the video for full functioning of the madrasa. Undersigned is also directed to request you to send a proposal of administration investigation. So this was the observation and order of the madrasa board, and on prompted the DI to issue in compliance with the direction. We have issued the video appointment of video on the next page 49, page 49.
Yes.
There are passwords for the appointment. Another affidavit I have found, my lord. That is L11. Is also filed it.
Yes.
The affidavit of respondent number 11. Which the party got
Police station.
I see for Rotwa police station, concerned police station of nothing. That direction, where direction, about the yes, my kindly page 2, paragraph 5. I first state that on 5th May 2025, one specific case has been recorded by PS case number so and so to the 5th May 2025 under section 300 BNS over the complaint of one district officer of the minority affairs Malda against one Anarul Haq, ex-PIC of the managing committee of the Patna Senior Madrasa Ratwa, and other deportation of the government money under Oikosri scholarship scheme. During investigation, the case IU attempted the following step. IU had been to PO, visited the PO, prepared rough sketch map of the PO with the index, examined the complaint, other witnesses recorded the statement under section 980 IO collected inquiry report on Patna Senior Madrasa regarding scholarship verification in the source. IO sent requisition to the PIC Patna Senior Madrasa requesting to supply the document mentioned in the requisition but he did not supply the request documents information till now. Although I sent reminder 2 times through PS mail as well as hard copy of the trigger. I also sent requisition to the district officer Manukiavel requesting to supply the documents mentioned in the requisition. I also served notice under section 35 to ex-PIC, junior, senior master Matua, Deputy Mawla, R and others who are involved in this case for the sake of investigation, but only 2% appear before you. I also served notice under section Sagar Jobidar, Tupol Jobidar, Suman requesting to appear before the they are also involved in this case. They know the fact very well. During interrogation, they provide some seals to take photocopy of the admission slip of Patna JMO senior master's. On 25th May 2012, I received some documents from the direct district officer Manukiavel at the Madrasa Education. I were all produced the document and found that some honorable Supreme Court Observation 1 committee report. On 29 May 2000, I received some documents from the district office minority by Mumana Maswan. So overall produced the document, found that they provided the name of the candidate who had verified by Masters of the only pen drive as soft copy downloaded for the footer. But the list for the year 2020 did not provide them. I was sending to the district inspector Vishnu Atul Chandra Market Pure Malda district request to supply a total number of enrollment admission student transport to a department for the year. State clear for admin section for original section.
Scholarship.
Police also taken the state.
Scholarship is
There are so many allegations against the management. Even the TIC admitted. Some witnesses report the police authority that there is a embezzlement of funds or and also for appointment fake admission or
It is scholarship fraud.
Scholarship manner. So upon taking into consideration, the board directed the district inspector to appoint DPO for protection that government money, public money, and to take necessary steps for appointment of approval. So this was that has been admitted. They did not. Therefore, they were asked to. Mismanagement, my lord. So I have stated the secretary, minority affairs department, all visited, and court inquiry was made. Yes, paragraph III. Second part. It is to be noted that the principal secretary, minority affairs, Madrasa Education Department, Government of West Bengal, District Magistrate Malda, the President West Bengal Board of Madrasa Education, the District Inspector of Schools Malda, and some other officials made surprise visit to the concerned madrasa on 10 June 2025. The concerned TI submitted that written declaration informed on this officer. He was forced by the secretary and other members on order to tender the education. So and on spot inquiry was made by all the officials. There may be some allegation against DI or something. So many officers visited from that day because they have to comply with Supreme Court's order. And in the meantime, it was detected there are so many irregularities in case of running a management.
চলে যাবে এখনই যেন চলে যাবে Yes.
My lord, with your lordship's leave, my lord, may I just quickly give reply, my lord, both to the contention advanced on behalf of the board as well as, my lord, with the contention of the state respondent, my lord. My lord, lordship recollects, my lord, lordship has taken a note also that the board prima facie contended before your lordship, my lord, that there was financial irregularities in the recruitment of teachers. My lord, but the board did not say, my lord, when that recruitment happened and which managing committee was responsible for those recruitment. Lord, at the outset, I submitted, my lord, that those recruitment pertains to recruitment made in the year 2015, 13-15, that span, my lord. And this board was formed sometimes in 2024. So, my lord, this board has no correlation with the board that allegedly have recruited those teachers. Number one. Number two, my lord, the other contention of the board was that, my lord, since we did not take steps to verify the document with regard to the recruitment that took place in 2015, so we should be liable.
Just a minute. But those teachers continue to be in the school discharging their functions, and
Yes, madam. Their services were initially protected by the Honorable Supreme Court, my lord. But later on, my lord, in a contempt proceeding, my lord, that order was modified. Then a committee was formed of Justice Day Committee, my lord, and that committee held in against those teachers. They went up before the Honorable Supreme Court by filing a writ petition under Article 32, my lord. That was dismissed, my lord. Finally, my lord, they were sacked, my lord, because of that. This is the background.
yes.
So, my lord, the present petitioner's culpability, my lord, is sought to be advanced before your lordship in the fashion that we, after taking over the managing committee, did not take step to find out the irregularities that took place in 2015, my lord, and that is how we are responsible for those recruitments, my lord, in 2015. My lord, if that be so, lordship may kindly take note that after the last managing committee was dissolved, there was an administrator which worked for 1 year, my lord, from 21/5/2023 till 12/8/2024, my lord. There was an administrator.
Date again. Date.
My lord, date is 21/5/2023.
Ad hoc. This is.
There was an administrator appointed, my lord.
Administrator.
Yes, my lord.
The last managing committee was dissolved on which date?
My lord, the day before that, that is 25/2023.
Appointed on administrator is
21. Yes, my lord.
26th May.
21st May, my lord, 2023.
No, last committee was dissolved on 25th May.
20th May, my lord, one day before.
20th May.
Yes.
Oh, 20th May. 21st May. 20 administrator appointed. Yes.
Yes.
Now this committee was formed on?
This committee was formed, my lord, on 13th of August 2024.
Yes.
So, my lord, if this managing committee is thought to be blamed because it did not verify the documents with regard to the recruitment of 2015, then, my lord, as a fortiori, the state, the administrator was supposed to be taken on task for failing in his duty in verifying the records of 2015 because he ran the show for 1 year, my lord. So, my lord, the state first need to blame its own officer and then the blame has to come before the managing committee, my lord, if that is the submission of the board, my lord.
Yes.
No, that was the first. Then, my lord, My lord, a document was placed in which, my lord, the teacher in charge made certain admission, my lord. I will just place the document, my lord, once for your lordship's recollection, my lord. Kindly have, my lord, page 28 of the affidavit in opposition of respondent number 224, my lord.
Yes.
Well, just give me a second, my lord. My lord, marks the date. My lord, the dates are there in the bottom, my lord. Mark the signature. Kindly mark the date that are alongside the signatures, my lord.
Page number.
Page number, my lord, 28, my lord.
Yes.
My lord, it was submitted that these teachers have made certain statement before the committee, and this statement was made during the tenure of the managing committee. During what is this? My lord, it was submitted, my lord, that the government could not take any step because the matter was pending before the Honorable Supreme Court since 2015. They took time from 2015 till 2025 to fix the blame on this managing committee because the case was pending before the Honorable Supreme Court. That was the specific contention of the board, my lord. I say, my lord, if the matter was pending, then the matter was pending also at the time when the managing committee took the step. So if the contention is that we could not take steps because the matter was pending before the Honorable Supreme Court, I say, my lord, if the matter was pending from 2015, whenever the first writ petition was filed, my lord, in 2025 also, when they took all these steps, then also a matter was pending, being writ petition 566. So that contention, my lord, I have that answer to that contention, my lord. So, my lord, and the conjoint submission will be, my lord. So they were aware of the irregularities from the very inception. If that be so, my lord, they say, my lord, they could not take steps because of the pendency. So that means, my lord, they were aware of the irregularities. If they were aware of the irregularities, why they allowed the other managing committee, which formed after 1516, to continue? Why?
No. If that is a mistake, that does not validate your action.
No, we have not done anything.
If they have not taken steps, that does not say that the committee did not have the responsibility to take steps.
No, we kindly appreciate, my lord. We had nothing to do about it. They were recruited in 2015 onwards. They filed their petition and their litigations was pending before the Honorable Supreme Court, and their matter was dealt independently, my lord. We as a managing committee was limited to our duty, my lord, to provide them with pro forma A that was asked from us. My lord, beyond that, we didn't have anything to do with this recruitment, my lord. Number one. Number two, my lord, in the submission, my lord, my lord, in the submission that was advanced on behalf of the state, my lord, it was said that nothing is being stated that we submitted those documents and all. My lord, it is a specific case, and I also placed it while placing submission, my lord, on the affidavit in opposition of the respondent number 8, my lord. He has specifically stated that, my lord, that the secretary came to his office, my lord, with some valuable papers, as your lordship indicated, my lord. He said nothing is there. These are all my submissions, my lord. Kindly have the affidavit in opposition of respondent number 8, my lord. Page 7, if your lordship kindly have, my lord. The second paragraph, my lord.
Yes.
Well, may I place it, my lord? The allegation brought by the concerned secretary are absolutely false and baseless. The fact is, kindly marks, my lord, the fact is that the secretary of the concerned madrasa visited the office of the district inspector of school.
This is which page number?
My lord, page 7 of the affidavit in opposition by respondent number 8.
The allegations, yes.
Yes, my lord. Does you have it, my lord? The allegation brought by the concerned secretary are absolutely false and baseless. The fact is that the secretary of the concerned madrasa visited the office of the district inspector of school Malda on 27/5/2025 at about 2:30 p.m. He tried to place some documents before the district inspector of school Malda. When asked why he is possessing valuable papers, document of the madrasa in violation of the rule 26 of the government notification number such and such, he failed to give proper answer. At that time, he left the bag containing some papers, kindly marks, my lord, not verified, in the office of DI Malda. My lord, this instance was never disclosed by the DI in any of the report that he placed before the board, my lord. My lord, in my respectful submission, my lord, if the DI admits that I have came with valuable documents, first, how did he know that those were valuables, my lord? Second, my lord, he said that he has not verified it. My lord, without any verification, how did he know that I am in possession of valuable documents? And number three, my lord, he said, my lord, that those documents were in my possession in violation of Rule 26. But he don't know the documents. He have not seen the documents. And he knows the documents is in violation of a particular rule. I don't know, my lord, how this is practically possible, my lord. And my lord, if your lordship recollects, my lord, this part, my lord, was only on my averment, my lord. I did not have anything to prove or substantiate this. This was dealing with paragraph, my lord. Paragraph made in paragraph 9 have made these averments, my lord. There was no record with me, my lord, no documents to prove it. Fortunately, my lord, since I have said that I have videograph of recording of that, he has admitted the fact that I went to his office and all this, my lord. Today, my lord, had I not averred those, my lord, and I could not have substantiated my case, my lord, that I went to his office with those papers and all. But these were not reported, my lord, to the board, my lord. So board took a decision, my lord, in my respectful submission on the basis of materials which were not fully true, my lord. Half truth, if I may say so, my lord. If not worse. In absence of a more worse term, my lord, I will use a better term of half truth was placed before the board. So the board was not apprised of the real facts, my lord, in my respectful submission. So the decision that was taken by the board, my lord, was not based on actual materials, my lord. It was half-baked material that was placed before the board. So the decision of the board on the basis of those material, my lord, in my respectful submission, was a decision in fallacy, my lord, because not the whole picture was not there before the board, my lord. That is, my lord, second. Third, my lord, now, my lord, if your lordship sees the learned counsel, my learned senior, my lord, page 48A in saying, my lord, can we have, my lord, 48A of respondent 8 affidavit in opposition?
Of repetition.
48A, no, my lord. The affidavit in opposition used by respondent number 8. Same document, my lord.
Respond number 8's affidavit in opposition ends with page 33.
But then, my lord, yes, I'm sorry, my lord. Read petition, my lord. Read petition, page 48A. I'm sorry, my lord.
Yes.
Now, my lord, the second paragraph was emphasized upon, my lord, by the learned counsel for the state, my lord. I will just place it before I place my submission, my lord. And whereas during the hearing, the secretary and the managing committee, secretary of the managing committee could not give any satisfactory reply regarding the mismanagement of the managing committee, Batna JMO Senior Madrasa. My lord, I've shown the, my lord, place the hearing notice, my lord. If your lordship kindly sees the hearing notice before this, my lord, kindly takes page, my lord, 44, my lord.
Well, kindly have, my lord. Subject, my lord. May I place it? Kindly see the subject regarding affairs of Batna JMO Senior Madrasa District Malda, reference such and such. With reference to the above, a hearing will be held on such and such at 1 p.m. The conference hall of Maulana Abdul Kalam Azad Bhavan, third floor, regarding affairs of Batna JMO Senior Madrasa. All concerned are requested to please attend the said hearing with relevant documents and papers. Now, my lord, kindly appreciate if this is a hearing notice, what I am supposed to do, what I am supposed to bring. Like there is nothing spelled out what is the hearing purpose about. Regarding affairs of madrasa. But affair of madrasa can mean anything under the sun, my lord. I have in a hearing notice where I have been asked to attend a hearing, I must know what is the hearing all about. But if an omnibus term like affairs of the madrasa is given, my lord, what is expected of me to say? But I have to be given a specific allegation to deal with, my lord. Now, regarding affairs, if I am called for a hearing, then what is the reply that they expect from me, my lord? This is the first thing, my lord. So, therefore, my lord, with this hearing notice, my lord, the with this nomenclature of this kind of or not the nomenclature, but the content of this kind of hearing notice, my lord, will make me, my lord, absolutely, my lord, incapable of giving any reply, my lord. With regard to affair of the madrasa, there can be anything, my lord. So, my lord, with this hearing notice in background, my lord, the reply sought from me, my lord, is as vague as it can be. Now, my lord, yes, my lord, finally, my lord, emphasis was placed on the affidavit in opposition used by respondent number 11, the officer in charge of a particular police station, my lord. If your lordship sees the order impugned, my lord, that has no discussion with regard to police report. So, my lord, if that has not been dealt with in passing the impugned order, I don't know how that is relevant at all, my lord. That's all, my lord. That is all, my lord. That is.
Mr. Sudhanshu Bhattacharya, learned additional government leader appearing on behalf of the state respondents who concludes his argument. Mr. Tanmoy Chattopadhyay, learned advocate for the petitioner, also concludes his replies. The hearing is concluded, judgment reserved and made CAB. That's all.
My lords, I'm extremely grateful that you have given us opportunity to argue.
Thank you.
Extremely grateful.
That matter. 1009 rules there is a bar.
Let me check it out. But since your lordship has
Yes, I asked Mr. Das that you inform Mr. বিশ্বাস.
told me that is why I have come.
Because that will be a wrong interpretation of law. I have to recall that order if 2009 says so.
Let it be. But I am not.
You go through that. I have not decided anything.
Whether prior to that, after that.
You go through that.
Yes, interpretation regarding repeal and savings, I have to check it out.
Yes, yes.
If it is there, your lordship may. Then I have an argument that functions of his part.
Yes, yes.
I cannot.
Section 40, rule 43 also you look through that. Of the new rule 2009.
Yes,
43.
but,
You go through that rules and then make your submission.
I shall. Let me check it. Check it.
You come back tomorrow?
Next week.
Next week.
Let me check it up, or tomorrow at so we mention, if your lordship feels that it is to be recalled.
Okay, I find out if the records can be brought, I place it under to be mentioned for clarification. In the meantime, you go through that and make yourself.
2009.
এটা দেখো তো এটা কাজল রানী জানা। You give the WPA number, Mr. ওটা রেকর্ডটা না একটু আনিয়ে নিন। ম্যান্ডামেসে আছে তো, নিয়ে এসে ওটা টু বি মেনশনটা একবার দিন। In the meantime, you go through it. Yes.
We may be wrong, subject to correction by your lordship, my lord. It can happen.
Okay, yes.
sometimes.
Yes. Next, রাখো।
My lord, I am for the petition. My lord, it was that library recruitment matters, my lord. These are the bunch of matters, my lord. Here in these matters, my lord, my learned friend, my lord, Mr. Bandyopadhyay has been appointed as amicus curiae, my lord.
By an order of 13th February, my lord, the erstwhile bench had been pleased to direct me to render assistance as an amicus my lord, in this matter. My lord, the petitioners first conclude thereafter.
Okay.
My lord, the recruitment relates
Just tell
to,
me the pleadings are complete.
my lord,
All the oppositions and the
my lord,
replies.
point of law, we have our affidavit in reply ready in this matter. My lord, this is the one, if your lordship decides one matter, my lord, points are same, everything without even exchange of affidavits. My lord, it has been served also. This is my
Swapon Kumar Datta appear reply. Who will represent the state? No, I have taken up 680.
But I am appearing on behalf of the local library also.
If all the matters are analogous, if state is represented by the GP, then
My lord, we are led by GP, not by GP, your lordship.
then you find out which are the matters in which opposition has not been filed. In this matter, affidavit in opposition filed?
Yes, yes. I have given my reply also.
Records. No, in this matter, affidavit in opposition has not been filed.
Affidavit in opposition not filed.
Might be the copy has been given to you, you have prepared your reply. Next
But
again.
when, my lord, only thing your lordship can hear it, only the points. I will not ask you, my request your lordship to, my lord, go to the brief. The point is, my lord, there is a notification of the labor department, my lord, that in case the vacancies of exempted category in respective, my lord, reservation, that is OBC, ST, SC, are not filled up because of unavailability of suitable candidates, that vacancy will be, my lord, converted to normal SC, ST, OBCA and OBCB. This is the notification. My lord, in our case, my lord, in the advertisement, one OBC exempted categories, OBCA exempted category was advertised. When the final panel was published, it is found, my lord, that nobody has been appointed in the OBCA exempted category, not even in the waiting list. I, my lord, in the waiting list, first rank 1 in OBCA. There were originally 3 OBCA vacancies. 3 persons have been empaneled and I have been placed as waiting list 1. Now my case is, if that OBCA exempted category, my lord, is converted to OBCA, then being waiting list 1, I will avail an appointment, my lord.
But the rule permits for conversion.
Yes, only one page I will show, my lord.
Page number 50, relevant.
My lord, page number 53. My lord, this is the relevant portion of the notification.
680 থেকে কতগুলো আছে? 680 থেকে কতগুলো আছে?
680 and 681.
My lord, he is appearing in 680. If your lordship so wants, my lord, I have
Mr.
a photocopy.
Bandyopadhyay has been appointed as amicus in all the matters.
My lord,
The order of 13th February, but since perhaps, my lord, it's my way of understanding. Since, my lord felt that all the matters are on the point of interpretation. In paragraph 2 of the order of 13th February, my lord noted all the matters to appear together. And in the next paragraph, merely said that Mr. Bandyopadhyay is requested to accept the comment. So I believe it is for all, but I have prepared myself on the point of law, but not only separate facts, if any.
Okay.
But as Mr. Dashgupta rightly summarizes, it is, if I have understood it correctly, that EC is to be converted to SCEC or OBC AEC, OBC BEC is to convert it to SC, OBC A, OBC B respectively. I don't think the state is taking a different stance. The difficulty here is that whether to do it in the same process or whether to do it in the next process. Whether I will take, when it is converted, I will take from the wait list of this process, or I again advertise.
Carry forward to further.
Yes, that is, I think, the point of difference between the two parties.
Yes, ma'am.
I try to assist the court on this point.
And if your lordship,
You,
page
Mr. Singh, you find out in which of the matters Mr. Roy will be appearing in other matters, whether oppositions has been filed in all the matters or not. You are for petitioners in all the matters.
No, not in all the matters. My lord, I am in 680, 681, 82, 83, 84, 86, 87, 88, 89, 90, 91, and 700. Up to 91 and 700. আমাকে অপোজিশনটা দাও তো স্টেটে।
আসুন তো। From 685 to 685, 686, same, similar.
Yes, my lord. From 680
Hmm.
to 691, same, and 700.
Oh. In between the matters, they are different.
No, my lord.
692,
My lord,
693.
these are the numbers, my lord. May I? অন্যগুলো আমি ঠিক জানি না।
Huh?
Stated.
হ্যাঁ
Stated তো।
1 2 3
এটা কি অন্য একটা দিন 691 অবধি
Yes, ma'am.
You take back the affidavit in reply. I am placing all the matters up to 691 and 700 on a particular date.
Yes, ma'am.
Both the parties, you find out where the pleadings are lacking. If any opposition is wanting, then you file that, state will file, and you file your reply.
Only one thing, since in item 680,
yes,
my lord, they have served me a copy of the opposition. I believe it is the original is maybe with the erstwhile advocate. May I give a photocopy of the opposition to them so that they can reconstruct and file it?
But in that event, they have to again reaffirm the.
Yes, reaffirm. Or my lord, your lordship, they can give this copy if the original is not available, or reaffirm.
It is not on record. Otherwise, I would have taken.
You can reaffirm it, my lord, because since it has already been that is.
এটাকে একটা ডেটে নিয়ে আসো, এটাকে রেগুলারাইজ করে দিই যে প্লিডিংস আছে। You check all the records whether affidavit in opposition has been filed or not. You inform the court, I am placing all the matters in a particular date. After the pleadings are complete, we can fix a date for hearing.
My lord, then may I, my lord, make one humble submission, lordship, place it after 2 weeks. In the meantime, my lord, if no opposition is filed, let them file their opposition so that it can be heard out, because my lord, it has been continuing for a long time.
Nintuda 680 থেকে
I am appearing for item number 681. My lord,
state.
For the state.
691 of the নিন আর 700 টা রাখবেন একটা ডেটে রেখে দেন ব্যাস একটা ডেটে করে নিন বলুন 2 weeks পরের ডেট দিন ওই ডেটটা ফিক্স করি নো অর্ডার্স 25th August কি বার পড়ে
25th আমার লেবার আছে
কটার সময়
ঠিক আছে ওই দিনের চেক করে আসুন on 25th August
my lord, any time, my lord.
4 p.m. 4 p.m. 25th August.
My lord, if it is little later, because on
Little later means after 4:30.
26th or
Later date.
later date.
No, on that day I take up library matters. So let us first find out and construct the pleadings and all.
So you have already all the copies of affidavit of
Yes,
opposition?
ঠিক আছে।
So how we can collect it? We have আপনার সমস্ত কপি গুলো দিয়ে দিন
আমি যেটা আছে সেটা দিয়ে দিই।
ঠিক আছে। Your lordship, we are trying to collect all the affidavit of opposition which are available.
If reaffirmation is required, you inform the court. so that leave can be granted to reaffirm
My
a
lord.
file affidavit in opposition. We'll
My-
regularize that. Don't
My
worry.
lord. My lord,
Thank you.
deeply grateful.
Deeply.
Enough.
82, 83.